Are here on cases S24Z1139 and S25Z0722 in re Judge Shermela J. Williams. As you all know, we're here just for closing arguments today. Before we start, if everybody in the gallery could just double check their cell phones. I'd hate for a cell phone to go off and interrupt someone's argument and interrupt their train of thought. So everybody please check. And Ms. Veal, are you planning to reserve any time for rebuttal, or how are you planning to do your argument? And just conclude. Okay. All right. Then on behalf of Judge Williamson, Mr. Banks, Ms. McFadden? Oh,
sure.
One thing. Go ahead.
We have a preliminary matter.
Okay, and I've just jogged my own memory too. I think we did need to put on the record the directed verdict information that we emailed you about. Didn't actually put on the record, but go ahead.
Thank you. Good morning, everyone. In response to the hearing panel's questions sent to the parties, the 5 or 6 questions, with respect to the first question about the stipulations, we have drafted a new amended set of stipulations that you can follow along with. And essentially, we have endeavored to make sure that the stipulations and admissions match the trial testimony. And so, by way of overview, all of the counts and allegations are admitted with respect to the delayed rulings, the MD issue, and the issue concerning Judge Williams' uncle. The only counts and allegations that are in dispute pertain to BA.
Got it.
Okay.
And the question, does that document replace the previous in its entirety?
It does replace
Okay.
it, and there's language to that effect included in the admissions and stipulations. I should also say that the way we've done this version is this is Judge Williams. We didn't set it up as a stipulation that was to be agreed upon by the director. It is just Judge Williams' admissions and stipulations only. And I handed a copy to the director a moment ago.
Okay. Ms. Veal?
So I did just get this a moment ago. I've looked over it. There's no place for my signature. As I indicated to the hearing panel, I think it was our last day of trial, I think the panel is going to have to make the decision about whether or not some of these counts and allegations were truly admitted. Because
You can't hear her. Can you speak into the mic for
Sure.
us? Thanks.
what I agree with is the document that was submitted on the first day of trial regarding the conduct that was admitted, and those are all the delayed rulings. And then that document also outlined the one count that I withdrew, which was count 6. But this document has different and new counts in there. And back to the issue that I was explaining on the last day of our hearing, Judge Williams' testimony has been inconsistent with some of the things that she is now admitting to. And so again, there's not a place for my signature on here. I do not agree to these later admissions, but I think it's up
Something
to the
to
panel.
consider.
Correct.
Okay, so then given the fact that the previous document, I guess, has the admissions you all agreed on and the count that the director's withdrawing, did y'all not want to withdraw that and leave that in the record, or, and I'm asking both of you.
The count that was withdrawn was a duplicative count. I don't know that there's any basis to not withdraw that count now. I don't know if you feel differently, Director Veal.
I'm sorry. The question is there reason to withdraw the prior document or leave it in the record?
That's my question, is, in other words, I realize you're saying it replaces it in its entirety, but the previous document was one that you both agreed on and contained a withdrawal by the director. So it was counts you all agreed on, plus the withdrawal by her. I guess the question is there any harm to leaving that one where it is and just understand you all are supplementing with this new document?
I'd ask that the initial document remain because of the position
And just to be clear, the director and I agreed during the last setting that some of the counts that were previously agreed were inappropriate to be agreed to because the testimony incorporated some allegations that were disputed. And so what we tried to do is just make it clear for the hearing panel, clear up that issue, plus, again, make sure that the admissions align with the testimony. And so with respect to the count that was withdrawn, I believe the director would agree with me that it should remain withdrawn because it was it was included in both sets of charges, to answer your latter question.
Count 10.
I don't
Does
have
that
it.
count 7?
6,
That was
I
count
think.
6. Count 6 of the second set of charges. So I have copies of the amended
That would be helpful, thank you.
admissions and stipulations, and we will file these.
Okay. We'll be glad to take those. And we'll need, I mean, obviously we want to look at that and look at the previous document, but at this point, it may just be that we leave everything in and kind of just evaluate everything in its totality. Thank you. For you. All right, and then Ms. McFadden, thank you for the preliminary matter because you jogged my memory. We did have, I think, the outstanding counts on the directed verdict motion, which we emailed you guys, I think, a week or two ago, just letting you know the ruling on that. But for our record, all of you, of course, know that those were denied. So I just wanted that to be clear in the record that those were not hanging out there, that we had denied those. So with that, are both of you closing or just Mr. Banks or?
I think I'm just closing.
Okay, well then
Although I'm happy to pass the torch.
we're ready for your closing if you're ready, Mr. Banks.
Good morning to the hearing panel. Back in the late 1980s, a 7-year-old little girl who was born and raised right here in Fulton County, Georgia, dreamed of becoming a judge one day. And while that little girl certainly hadn't worked out all the details of how and when her dream would become a reality, she knew at the early age of 7 that she wanted to be a judge. Raised and reared in Southwest Atlanta, affectionately known as the SWAT, attending the public school system right here in Fulton County, Georgia, ultimately graduating from high school. That little girl began to work very hard to make her dream someday, some way, a reality. After graduating high school, she went on to the Howard University, in Washington, D.C. And then once graduating there, she earned her law degree from the University of Georgetown. After graduating law school, she went on to serve as a prosecutor out as her first job as a lawyer. And she did that in the community of Philadelphia. She did that for approximately 3 years, perfecting her gifts and talents as a trial lawyer, and where she tried north of hundreds of cases, including bench trials. Before returning to her roots, she sprinkled that prosecutorial experience with some civil litigation where she joined a firm based out of West Virginia. She eventually moved back to Georgia. And when she moved back to Georgia, she rejoined the ranks of being a prosecutor, where she served as a prosecutor in the Fulton County District Attorney's Office, ascending the ranks and becoming the youngest prosecutor, if you will, to try homicide cases there in the Major Case Division under the leadership of former DA Paul Howard. After finishing her stint in Fulton County, she then moved on to the DeKalb County District Attorney's Office, where she continued to perfect her gifts and talents as a trial lawyer and tried cases, murder cases, as well as cases against women and children in the Crimes Against Women and Children unit. Ultimately, trying to keep her eye on the prize of that dream she had as a 7-year-old little girl, she completed her stint as a prosecutor and then rejoined private practice with the firm of Thomas Kennedy, Sampson, and Tompkins, where she handled very complex civil litigations on behalf of plaintiffs and victims catastrophically injured, as well as corporate defendants who were sued for an array of issues. At some point, she decided to push that envelope to pursue her dream to become a judge. And she didn't do it, she tried to do it the traditional route initially. She submitted an application for appointment, actually 2 applications. Those applications fell on deaf ears, and then she had to make a decision. Do I continue to practice in private practice and allow my formidable years as a lawyer pass me by, never realizing my dream, or do I put my name on the ballot? And she decided to put her name on the ballot in the very community in which she was born and raised, and she qualified for the seat she now holds back in March of 2020 and was eventually elected by the citizens of Fulton County in a hotly contested race against a very formidable opponent, then former Judge Reeder. The people, she did it, and the people of Fulton County elected her and cast their vote of confidence in favor of her to replace a very formidable opponent. And so at some point while serving, these charges came about. And even after the charges became very public and she received a lot of criticism, she was reelected again, and ultimately was reelected with a very deciding vote. She didn't have any opposition, but the citizens of Fulton County, knowing full well that the charges were pending, reelected Judge Williams, and that is so vitally important because the people's choice matters. And I would ask that you keep in mind as you make the appropriate decision in this case that she was an elected public official who ran for office and who ultimately gained and garnered the support of the Fulton County citizens. Before I get to the substance of the arguments, I do think it's worthy to point out that Judge Williams, from the very inception, when she received a letter of inquiry from the JQC concerning the charges involving Brandy Alexander, tried to resolve these charges from day one. She was trying to accept responsibilities for those things to which she could accept responsibility for. And that's not just true about the June 2024 charges. When the February 2025 charges came about, she also attempted to resolve the charges short of this extensive, now trifurcated proceedings. And so I think her willingness to try to resolve these matters when ultimately these charges came about is extremely important to this hearing panel's consideration. But getting to the formal charges, as the hearing panel knows, essentially there are now one set of consolidated charges, right? And those charges are made up of the 2 separate formal charges, but the first set were filed in June 2024. And counts 1 through 6 deal with the ex parte communications with Brandy Alexander. Count 7 through 17 deal with the delayed rulings that occurred and were the substance of those 2024 charges. In 2025, February here more recently, a new set of formal charges were filed, and the first 3 counts deal with the arrest of Molly Dennis. Counts 4 and 5 deal with the call on behalf of her uncle. Count 6, as you heard, has been dismissed by agreement of the JQC because that count was a delayed ruling, but it was duplicate of one of the counts in the June 2024 formal charges. And then ultimately, counts 7 through 15 deal with another set of delayed rulings. So there are 4 categories of charges: the ex parte communications, the arrest of Molly Dennis, the call on behalf of her uncle, and the delayed rulings. I want to talk to them, I want to talk about them in that order. Look, I'm not sure what to say about Brandy Alexander, but we can start by her testimony where she came to this court in an open proceeding and threatened an elected official. I mean, I don't know if you guys heard what I heard, but she threatened an elected official in an open proceeding. And the reason why I say she threatened is because she had testified previously before the investigative panel. She never mentioned anything about take my child and I will burn your house down with her in it, with you in it, you being Judge Williams. That is what that officer of the court, a member of this bar, came in these open proceedings and said before this panel, and it was nothing but more than a threat. And I invite the JQC to say otherwise. Because why wait until the day you testify at a proceeding to ever say something like that in the presence of Judge Williams? It was a threat. We took it as a threat. And ultimately, I will just say this. That frames the issues of her credibility. This woman is unhinged. She is absolutely unhinged. And ultimately, my question for the JQC and for this hearing panel is, and when I say JQC, please understand I'm referring to the investigative panel and the director, is how didn't they know this before they brought the formal charges? Why didn't they know this? And I'll tell you why they didn't know it. Because they had prosecutorial blinders during the course of that particular investigation, and frankly, all of the investigations, and that is the overreaching elephant in the room. And I want to talk about some elements before I talk about the actual counts, but one of the elephants in the room is the fact that the JQC conducted a very biased and one-sided investigation. How do we know that? The JQC failed to interview critical witnesses who were present at the time the ex parte communications occurred. These ex parte communications occurred in October of 2021. At that time, Janelle Bowles was working for Judge Williams. Soraya Ward was working for Judge Williams. Will Wooten was working for Judge Williams. And although Tangi Bush was not working for Judge Williams, Tangi Bush, her name was mentioned by Brandy Alexander in her comments and her interview to the investigative panel as attributing some comments to Tangi Bush. They didn't interview a single one of those witnesses. And yet they want to stand up here and ask for a judge's removal. Why didn't they interview any of those witnesses? 3 of those witnesses were present on the day that the ex parte communication occurred. Will Wooten passed the note to Judge Williams. There's a discrepancy as to whether Janelle Bowles and or Soraya Ward talked to Catherine Franklin. But at the end of the day, all 3 of those witnesses were present on the day in question. And at some point or another, all they do is interview Brandy Alexander and then ultimately file a complaint. It's interesting, particularly as it relates to Janelle Bowles, because Janelle Bowles, in the formal complaint, has statements attributed to her. She's named in the complaint. They don't even interview her prior to filing the formal charges. They just accept Brandy Alexander's word as the gospel. We know it's not. You saw her testimony. She is probably the worst witness that I have seen testify as a member of the bar. She is literally unworthy of belief. The witnesses that they did interview, Brandy Alexander, Edidion Aaron, well, they testified. You have their testimony, what they said here in open court. They say the exact opposite. They also testified before the High P panel. They said the exact opposite then. How do you have two separate witnesses saying the exact opposite, and then you step back and say to yourself, I can prove by clear and convincing evidence that these violations occurred? It's because they had their prosecutorial blinders on, and they had a decision about what the ultimate resolution was for Judge Williams, and the only resolution that has been extended or offered is removal. Let me talk to you a little bit more about some of those elephants in the room. They interviewed Don Smith. I mean, she's an officer of the court. I mean, she refused to talk to us. Commissioner Hyde, you asked her, why wouldn't you talk to him? Look, I've been in some very contentious cases. As the former game prosecutor, I mean, I have prosecuted a number of witnesses or a number of defendants who have threatened individuals, who have retaliated against family members, who have blown off people's limbs for cooperating with law enforcement. This officer of the court sent us an email when we reached out and said she'd feel more comfortable talking to the parties on the record. Why? What were we going to cook her and eat her? She's a fact witness. We wanted to know what it is she was going to say. But she felt more comfortable, at least in telling us, of talking to the parties, both the parties on the record. Well, we know that that's not true because she talked to the JQC. And it ultimately goes to bias. And then I will say this, while the rules don't require it, we didn't know what Don Smith was going to say. We didn't know what Catherine Franklin, who refused to talk to us, was going to say. We didn't know what Bonnie Stinson was going to say. And while the rules didn't require them to turn over what was said during those interviews, we're talking about an administrative proceeding. And when lawyers are reaching out to try to talk to the lawyers and they refuse to talk to you, it ultimately begs the question of what is the process that the JQC is implementing to ensure that judges comply with the code of conduct. Is it trial by ambush? And this one-sided investigation, the reason why it's significant and the reason why I'm spending some time on it is because it goes to the objectivity or the objectiveness of any recommendation that the JQC will make in this case. And so let's just talk about why Brandy Alexander is unworthy of belief. First, the timing of her motion, the timing of her JQC allegations and her motion to recuse. You know, this conversation, the alleged ex parte conversation happened in October of 2021. She waited 3 months to file her motion to recuse. 3. And in between the time that the ex parte conversation took place and ultimately the time that she filed her motion to recuse and eventually the JQC complaints against Judge Williams, there are 2 things that happened. One, they showed up at a hearing before Judge Williams in December, and it was a status preliminary hearing, and ultimately the issue of recusal came up. Brandy Alexander didn't remain silent through her lawyer as it concerns the issue of recusal. She argued against it. And then they reappear for another hearing. At that hearing, there were some tough things going on in Brandy's camp, and she felt and got the impression that the judge was going to rule against her. And then comes the motion to recuse and the JQC complaints. How telling. On the one hand, you wait until the judge starts to act disfavorably with you to file a motion of a conversation that you say was so incredibly inappropriate 3 months earlier. It goes to the heart of her credibility. But let's talk about her affidavit. And I don't have the exact number, but I will just say this. I would invite the hearing panel to review her affidavit because her affidavit is inconsistent with her testimony here before this panel. And the critical issue about the affidavit is simply this, that at the end of the affidavit, it says literally, I am filing this motion because I believe that Judge Williams will act more favorably to me than the father of my child. That's what the affidavit says, a sworn testimony affidavit that was submitted in support of her motion to recuse. Says that I believe that out of the goodness of my heart, as an officer of this court, I've had an epiphany, and I need to make sure that the proceeding is fair to the father of my child, and so therefore I have no choice but to do this Good Samaritan deed and file this motion to recuse. Well, you know, she testified the exact opposite at this hearing when she sat in that chair. She said that she knew that the proceedings were going wrong. She believed that Judge Williams was going to take her child for her, and that's when she filed the motion to recuse. And again, her words ring so true about her credibility. If you take my child, I will burn your house down with you in it. She is a walking contradiction, and she offered perjured testimony during this proceeding. It's also important to note what her affidavit doesn't mention. Her affidavit makes no mention of the shield, on the shield comment or sorrel comment. Now, that was interesting because when you first file your motion to recuse, if you're saying that this judge can't be fair, why wouldn't you put everything in your affidavit about what was said during that conversation? You eliminate literally the thing that ultimately now the JQC has filed in the formal charges and making an issue out of? It calls into question everything that Brandy Alexander has said to this hearing panel. What else did she lie about? Even Don Smith, who wouldn't talk to us prior to these proceedings, Don Smith, her testimony was that she never heard Brandy Alexander say anything about, or that Judge Williams say anything about on the shield. She never heard that comment. That comment only comes from Brandy Alexander, who we know you can't believe her. 3 witnesses testified that she lied. 3 witnesses. Adidion Aaron testified that the things that she is saying that I said, or that the judge said, one, the judge didn't say that, and I never said that to her. Tangi Bush, the claim that Brandy Alexander had a conversation with Tangi Bush, and Tangi Bush told her she's going to take your child back in that ex parte proceeding, and she's going to weaponize your child against you, and she's going to make your child say favorable things about her father, and ultimately you'll never get any more business. Look, Tangi Bush was on their witness list, on our witness list. We didn't intend to call her. I get it. It was technically a violation of the rule of sequestration. I mean, they had full opportunity to cross-examine her. When she heard that testimony, ultimately felt it important enough to say, hey, that's not true. That is simply not true. And so you have several witnesses that are coming and saying that Tangi Bush or Brandy Alexander lied about things that I represented that was said. She lied about her salary. You know, when Director Ville tried to figure out what the impact of all of this had, she talked about how she doesn't like to practice law and how she was making nearly $500,000 a year and not making close to any of that. Well, we know she lied because we pulled up her testimony from the transcript of the hearing that she had before Judge Williams, where she tried to get a modification in support, representing that she only made $168,000 at that time. But now all of a sudden, before this panel, the impact is so grave and so grandiose that I'm losing close to over $250,000 worth of business because of Judge Williams. I mean, while I started asking her questions, it's important that I did explore issues of her prior employment. And interestingly enough, I questioned her about allegations that she made while working as a public defender. And those allegations were that a client stalked her and that she was terminated for her. If you review her testimony very closely, what I recall is that she ultimately indicated that she was never terminated for that reason, but she never denied that she made the allegations. So what's left? What do we have left from all of that? We know that a call occurred, right? We know from Judge Williams' testimony that there was no intent to have an ex parte conversation. And that's incredibly important, right? She received a note from Will Williams, and the note had Brandy Alexander's name on it and also senior judge. And Judge Williams made the call because Judge Williams wanted to figure out what was going on, and she believed that it was about a case involving where Brandy was a Gale, where she served in her courtroom. And so there was no intent, even early on, to have an ex parte conversation with Brandy Alexander. Now, against her better judgment, once she found out about the fact that it was an ex parte conversation and Brandy was a party to the call, she, against her better judgment, continued the call and continued to talk. But it's important to note that there was no discussion about the substantive merits of her case and no evidence presented that the call strategically advantaged one party over the other. There was no evidence presented about that. In fact, Brandy testified, if you want to believe her, but I say don't believe her, believe Judge Williams, that at some point during the call, there was nothing substantive in nature that was talked about the substantive merits of her case. It was about a procedural matter concerning removing the case to a senior judge, which Judge Williams says, we don't do it like that. I mean, I can take it off the mass calendar and keep it on a judge's track. And the reason behind that was to ensure that Miss Alexander's dirty laundry didn't get aired. There's nothing about that strategically advantaged Brandy over the father of her child. Nothing. During the call, Judge Williams offered to invite Brandy Alexander's lawyer to the conversation. Hey, let's talk. Let's bring your lawyer in. Let's have a conversation. Let's tell her about what the plan is. There's no evidence that Judge Williams knew Catherine Franklin. She was a lawyer that represented Brandy Alexander. They've never been to lunch. They've never met. I mean, there was no personal relationship. And so if there was this grandiose conspiracy to strategically favor Brandy Alexander over the other party, why invite someone to the conversation, another member of the bar for that matter, to the conversation if you're up to no good? Inviting Brandy's lawyer to the conversation is more consistent with the fact that after the call, she immediately tells Janelle to make provisions to let the parties know about the call. She instructed Janelle Bowles. And Janelle Bowles testified that ultimately she received that instruction, but she failed in carrying out that instruction. And so we know that at some point that instruction was made because that's what Judge Williams testified to. That's what Janelle Bowles testified to. And ultimately, she made provisions to ensure that the opposing side was aware of the call. Now, we also know that the parties were never informed. She testified to that. And Judge Williams has acknowledged her failure in that regard. I think it was Commissioner Lopez who says, well, you know, did you follow up? No, I didn't, and I should have. So that's what we have left. And so I would like to, at some point, review the individual counts, right? And one of the reasons why we contest, and I have some copies of the counts if you need them alongside, if I can approach. I just don't know, switching between the PowerPoint presentation and the lectern that's a little bit complicated. So when you talk about count one, the reason why we haven't admitted allegations in this regard, it's not that we haven't admitted specific conduct that has occurred, but the manner in which the charges are pled is concerning. So when you parse this out, essentially, there's no doubt she called the respondent, Brandy Alexander. Brandy Alexander, count one, was a litigant in a pending case. She called her on her personal cell phone. And it's important, all of that's true. Assuming all of that's true, there's nothing improper about that. Brandy Alexander is a Gale in a courtroom. And the reality is that why it's not improper is because when at the time that she made the call, Judge Williams did not know that she was making a call to a party about a case that party was involved in. And so they did talk about the case, but there were no substantive merits of the case were discussed. Even Don Smith doesn't say any of that. Don Smith didn't like the call. She said it was the worst call that she's ever heard. Having said that, Don Smith never made a complaint. Don Smith never called the bar and said, hey, this is a problem. Why didn't she do that? And then at some point she offered to handle and later actually handled the scheduling of the respondent's case differently than other cases. Well, the reason why we can't accept that as true or as pled is because you heard Judge Williams' testimony about how she handles certain cases. There are transgender cases. There are sometimes celebrity cases. There are cases involving Fulton County employees or sheriff deputies that ultimately she removes, not because she has to, not because the law requires her to, not because the law doesn't require her to or doesn't permit her to, but in certain cases, she will take it from the mass calendar and put it on her track to protect the integrity and the privacy of those litigants involved, and that's what she was trying to do with ultimately Brandy Alexander. And so this notion, the way this is pled, that somehow or another she was handling it some different way than the way other cases are handling is simply not true, and the reason why we can't ultimately admit to those allegations as pled. If you look at count two, we just vehemently deny that she allowed her relationship with Brandy Alexander to influence her conduct or her judgment in this case. First of all, what relationship? I mean, she didn't know Brandy Alexander before she was elected. She didn't. She had no relationship with Brandy Alexander. I think the overwhelming testimony and the consistent testimony was that at some point after she was elected, she met Brandy Alexander via Zoom. and Brandy Alexander introduced herself. And then at some point, Judge Williams began to assign cases to her. But there was nothing about that relationship that would have impacted the judge's ability to handle a case that involved Brandy Alexander. And certainly, we know that, at least according to Brandy, that she thought the judge was going to rule against her after the second hearing. And so take a step back and think about that. If her relationship with Brandy was really affecting her, you would think that you would agree with Brandy's initial false statement that is, I have to recuse because in the goodness of my heart, I want to be fair to the father of my child, who she loathes, by the way. And ultimately, I think Judge Williams is going to be biased in my favor. That wasn't happening. And she clearly understood that that wasn't happening. There was nothing about the relationship between Judge Williams and Brandy Alexander. It was a professional relationship where she was assigned cases as a Gall. I've said Gail, Gall, tomato. I apologize. But she did talk to her on her personal phone. She did speak with her about her case, but not the merits. And Rule 2.9 is very important, right? This is 2.4, but she didn't talk to her about the merits. And later actually handled or scheduled Brandy's case differently than the other cases. That's simply not true as to how Judge Williams handled her courtroom. That is not true. They have not proven that by clear and convincing evidence. Count 3. This is a violation or an allegation that she violated Rule 2.9a. Well, if you really read that rule closely, if you really
That needs to be turned off, sir, completely off. Sorry, Mr. Banks.
That's okay. That's my law partner, Sam Weaver, and I'm going to have a conversation with him about this afterwards. All good. Well, I don't know if I can scold him. He's a partner, and so, but we will have a conversation. But count 3, Rule 2.9, if you review that rule carefully, it does say that ex parte conversations with parties and litigants are prohibited. But it also makes the exception, right? And there are times when ex parte communications are permissible if they deal with procedural matters or administrative matters, so long as you don't talk about the substance of the case, right? And so long as the conversation in the judge's mind doesn't strategically advantage one party over the other, and then at the end of the conversation, so long as the judge makes prompt provisions for the opposing side to learn of the conversation. She was trying to alert her counsel in the conversation, but she called Janelle Bowes and told Janelle Bowes, or not called Janelle Bowes, but she talked to Janelle Bowes in her chambers and said, hey, make sure you contact the other side. Now, that didn't happen, but if you look at Rule 22.9, it doesn't say, that the actual, advising the parties is required. It just says that you're supposed to make prompt provisions. And I'm not trying to be cute, but I'm just saying a strict reading of that rule, the intended purpose is that the opposing side should be alerted. That attempt was made. But more importantly, it certainly wasn't an improper ex parte communication because it wasn't about the substantive merits. It was about a procedural matter, removing the case from the mass calendar to ultimately the judge's track. If you look at count 4, well, this is real easy, right? Because count 4 alleges that at some point Judge Williams failed to act and promote the confidence in the independence, integrity, and impartiality of the judiciary by commenting to EA that she was going to show Brandy Alexander personal in reference giving custody of Alexander's child to the father prior to the conclusion of the hearings. Well, they haven't proved that at all. I mean, the person that could have confirmed that allegation is Adidion Aaron. And she came in here and said, one, Judge Williams never said that. And two, I never said that to Brandy Alexander. They haven't proven count 4 by clear and convincing evidence because the sole witness who could have confirmed it simply denied that it ever happened. The same is true as it relates to count 5, stating that she acted with inconsistent with the impartiality of performance of her adjudicative duties of judicial office in violation of 2B1.2.10b by stating to Adidion Aaron during a discussion about child custody matters generally that Judge Williams starts from a place of joint custody in child custody matters and tells the parties to get her away from that place. Well, look, Adidion Aaron did say that, as did the judge. But more importantly, the statute governing domestic cases, there is a presumption that custody is not favored over the father or the mother. And so how is this an improper conversation? How is this a violation of the rule? Just stating how generally she handles custody matters. I start from a neutral to Judge Williams, and it's a fair reading of the statute in light of the presumption. Neutral is I start from a place of joint custody. You tell me how I should be custody for the mother or custody for the father, sole custody that is. This is not a violation of the rule. This is simply the judge telling Adidion Aaron how she governs the proceedings and what her judicial philosophy is generally in custody cases. I submit to you that they have not proven by clear and convincing evidence that that is a violation of Rule 2.10b. Count 6. And I know I've spent a lot of time on a case where the witness, the JQC star witness that is unworthy of belief, but I'm getting through it. But count 6, it's a 2.5 violation. Well, when you read that rule, I mean, all of the commentary for the most part deals with a judge performing weddings. Commentary 1, commentary 2, commentary 3. It's all about performing weddings and administrative duties. I will submit, in my opinion, that Rule 2.5 doesn't apply to this case. It simply doesn't apply. It's another way to try to add another charge, like some catch-all charge or omnibus charge, to try to accuse her or dirty up or silly up the formal charges, to just leave her with the impression, if I don't get her on a 1.2 violation, I can sure get her with the 2.5 violation. But if you look at 2.5, if you sustain that, which I don't think you should, because I don't think that they've established that by clear and convincing evidence. But here's the problem with this hearing panel saying that they've proven that that count. The count involves, just to bring back your attention, there was a motion to recuse filed. Judge Williams eventually entered an order and ultimately disagreed in the order with some of the factual representations in the motion to recuse. And so, look, judges disagree with me all the time. Sometimes they do it in writing. Sometimes they do it on the record. If I'm making representations about what transpired in a particular proceeding, or if I'm making representations about what a judge may have said, a judge may say all the time, yeah, that mischaracterizes what I said. That is a misrepresentation of what I said. What are we coming to if at some point a judge at some point clarifies the record? She didn't need to because she was ultimately recusing herself, but just because she did, then she violated it? In some way she acted biased or prejudiced because she disagreed with allegations that were lodged against her? That clearly can't be the purpose and the design of Rule 2.5 and any violation thereof. And so, for all of those reasons, I would submit that they have just failed to meet their high burden of clear and convincing evidence. Heck, they haven't even gotten beyond the 50-yard line, which is a preponderance of the evidence. They got to get in the red zone for me on a clear and convincing. Right now, they haven't even gotten beyond the 50-yard line. And oddly enough, this is the case that served as the impetus of this investigation. I want to talk about the delayed rulings now. In context,
Before you move on,
yeah,
can you address Dawn Smith a little bit more? I mean, she's seemingly a disinterested witness who has no dog in this fight. Seemingly heard the conversation, and despite the fact that she did not hear the on the shield comment, she does confirm, or at least testified to, the substance of some of the other allegations about the mention of the word soror several times, the I'll have your back. I was just looking back through my notes. There are several parts of her testimony that did confirm some of the allegations, so I do want you to talk a little bit more about.
sure.
I understand that she did not file a complaint, and that's, I get that, but completely disinterested witness, credibility-wise, what do we do with that?
Sure. I will say I don't think she's completely disinterested for this reason alone. She is Brandy's mentor, longtime mentor. Brandy is renting office space from Don Smith, right? And so when you look at that kind of colors, in some respect, her perspective on what transpired. And I'm not trying to cast aspersions on Don Smith. I do think she has a bias. And she's also not a disinterested witness when she refuses to talk to members of the bar, right? When we tried to interview us, I mean, we got crickets. In fact, not crickets. We were told, no, I'm not talking to you. And so I think you have to view it in that context, and to suggest that she's totally disinterested is inconsistent with those facts that I've just borne out. Having said that, look, she did testify about the soror comment. But to the extent that this hearing panel believes that the soror comment was made, not on the shield, because she didn't say on the shield, she did say the soror comment. I will just simply say this. If it was made in the context of a procedural issue. And I have your back could only have been interpreted to Brandy and to Don. That is, I have your back because I don't want your dirty laundry aired in public either. And so what I'll do is ultimately move it from the mass calendar to the judicial track. And so I will just say it wasn't, I have your back, I'm going to rule more favorably for you. We know that didn't happen. We know that that's ultimately why Brandy Alexander filed a motion to recuse. And so I mean, I don't know if that addresses fully your question, but at the end of the day, I do think the comment of SOAR is I mean, if you say that it happened, if you believe that it happened, it wasn't, I'm going to try to rule more favorably for you or strategically advantage one party over the other.
Well, the thing I'm struggling with a little bit is Judge Williams categorically denied saying anything about SOAR. Not that I don't recall saying that, but just I would never say that. I did not say that. So I'm trying to weigh Dawn Smith's testimony as a potential credibility question for Judge Williams. And so that's where I'm sort of struggling a little bit.
Sure. Well, I think ultimately that's an issue that will remain to be struggled. I don't disagree that Judge Williams said that she did not say that, but it's not just Don Williams who said that, but Janelle Bowles also said that she didn't hear the judge reference or use the word SOAR. In fact, that indicated very specifically, and Janelle Bowles is her sorority sister, that judge doesn't talk like that. That's not her nomenclature. I mean, it's just something that she doesn't say. And so, look, I think it's a fair point that you're raising, but at the end of the day, I will say she's not a disinterested witness. And what I want to say about those proceedings is is ultimately we didn't know what she was going to say. We heard that for the first time when she took the stand, right? And so,
But couldn't you have subpoenaed her to take a testimony, any witness?
I think that's fair. I mean, that's a fair comment. There's a discovery period.
And you have the same subpoena authority as the director does once charges are filed, right?
Right. Once charges are filed, we can go through the discovery process. We can have a deposition of a witness. But why should we have to spend more money to simply talk to a member of the bar, right? Who clearly lied to us because what she said to us was that she felt uncomfortable talking to the parties except on the record. And that's not what happened with her testimony. And so while maybe, I mean, her testimony is what it is here in the hearing panel, I mean, she wasn't totally honest with us in why she felt comfortable talking to the JQC versus us. And so, but we shouldn't have to expend resources simply to talk to a fact witness. Generally, what happens is you call them up, and then ultimately, you were a former investigator. When you interviewed a witness, you memorialized it in writing, you put it in your file, and you sent it off to the solicitor and or the district attorney's office. And then at some point, it got disclosed.
I wasn't very good, though.
Well, I don't know about that.
Don't use me as the gold standard on what's.
All right. I do think it's time to shift gears toward the delayed rulings. And as we said in our opening, context matters. And I will say when she testified, it's important to note that when Judge Williams took the stand on the first day of these proceedings, she was on the stand for the entire day, subject to Director Ville's cross-examination, and rightfully so, subject to the questioning of members of the hearing panel. And I believe she took ownership of the charges despite what Director Ville is saying. And so she admits the violations of misconduct associated with the delayed rulings. She also acknowledged and understands the importance of managing her docket and ruling on matters in a timely manner. She also testified that she understands the adverse impact failing to rule timely on matters has on the parties and litigants, including the rulings, not just generally, but rulings specifically that she made and delayed in this case with respect to the litigants and the parties that appeared in front of her. She publicly apologized to the parties and the litigants during her testimony. And I know that there's this big to-do about, offering a public apology on the stand is different than apologizing prior to the proceedings. But the reality is that she was instructed, rightfully so, not to have any contact with the parties to the subject of the complaints. And she followed that advice. But nonetheless, I asked her specifically when I called her to the stand, you heard the testimony of the two witnesses that talked about the failures or the delayed rulings, one of whom was in tears and talked about how it impacted her. And she says, look, I take full responsibility. I hate that something that I did, caused litigants and parties who appeared in front of me to feel that way. And so she's acknowledged that and publicly apologized. The staffing challenges, which contributed to the delays, not worth the sole cause. She said the buck stops with her. If there was a managing issue, she indicated that I am responsible for managing my chambers. But the staffing challenges that she had that contributed to the delayed rulings, they have been resolved. New staff attorney. She hired one. She implemented the implementation of new systems to ensure that this never happens again. And in fact, during her testimony, she indicated that she didn't have any matters or orders that were pending longer than 30 days. Context matters, and I don't want to beat a dead horse about the failed investigation, right? But I'm questioning what the purpose of the investigative panel is when they bring charges against judges, right? Is it just to point out that you violated a rule, or is it to try to find a way to figure out if this judge is truly redeemable? Because it's easy to point out a violation. You violated, but when you conduct a one-sided investigation, even as it concerns the failures to rule, the problem becomes, what is your ultimate goal? What is your ultimate aim? Is it really to say, okay, or figure out if a judge is truly unfit or has redeeming qualities or can continue on the bench? And the reason I say that as it concerns the failures to rule is because the JQC simply got the timelines of the cases and the length of the failures to rule. That's it. They didn't want to know the numbers and how those numbers compared. How her failures to rule, the 15 that are alleged, how those compare to her overall numbers. We introduced this exhibit. It's the case summary from the Family Law Division, and what we know is that context matters. The numbers matter. She inherited the worst caseload in the Family Division, Division 3. And there was, I don't say it's a discrepancy, but there were, the exhibit we introduced indicated that when she took the bench in January of 2021, she had 630 cases. But remember now, that chart did not account for the pre-judgment matters or the post-family judgment matters, right? I tried to put that initial in there to remind me, but I knew I was going to mess it up. And so what you heard from Tangi Bush and what you heard from Judge Williams is that Tangi Bush being her first judicial assistant that she inherited from the prior staff, look, what you heard from them is that when they printed out the docket of cases, they had 800 cases, not just 636. And that would have counted for those post-family judgment matters that were not accounted for on this chart. And so you don't see that number, and so all you see is the 636. But regardless of whether you want to take on the very conservative side 636, or you want to take or accept Tangi Bush and Judge Williams' testimony that they had a total of 800 cases, when you view that in context of the 15 delayed rulings, it's less than 3% to 2% of her entire caseload. Those are numbers that matter because they provide context. I mean, if you're watching a football game and then at some point you have to make some comments about it Monday morning, and the quarterback had a 97 or a 98% completion rate, but made some mistakes along the way, you wouldn't be saying that quarterback willfully and persistently failed in his duty, his duty, yeah. You just wouldn't say that. And so context does matter. I do think it's important to talk about, because I know the JQC is going to come up and say, hey, look, we sent that initial inquiry about the letters in July of 2023. Judge Williams responded in August of 2023. There were 11 cases in that letter that talked about, hey, these are delayed rulings, right? And you need to address them. And Judge Williams responded in August and said, look, I should have them in the next, by the end of the close of business next week. Well, she made every effort to meet that self-imposed deadline, and unfortunately, she was just unsuccessful, right? But it's not like she thumbed her nose at the JQC's letter. I mean, I believe her testimony is that she resolved 7 of the 11 cases that were on the JQC's letter of July 2023. And so, look, I'm not suggesting that she shouldn't have been more aggressive with handling those other 4 matters. Having said that, we can't sit here and say that she just willfully ignored or engaged in willful and persistent misconduct, because at the end of the day, she was trying to address the matter. And that is, I mean, in July, I think that is around the time that Brittany Green started with her. And Brittany Green testified, her new staff attorney, that her and the judge combed the docket and they developed new systems. And they had to go through all of the cases, particularly in light of the JQC's letter, to ensure that all of the cases, I mean, none of the cases had more than matters pending more than 90 days. And so they were aggressively trying to track all of her cases. And while she got this letter and that letter identified 11 cases, the reality is that she did the best she could during that time. The context matters because you should also know that on average, she took in over 90 cases each month. On average, she closed out over 100 cases each month. Well, you know, the JQC, when Mark Bryce was testifying, was trying to elicit testimony from him about the number of cases he closed out while being a JO with Judge Williams. And so, as if to make the suggestion that somehow or another that Judge Williams didn't really have that big of a caseload, it was the worst caseload. It was the worst. And the fact that she had a JO assisting her, well, so did every other judge in that division. Every judge had a JO. And so, but if you take that line of questioning to its logical conclusion, let's just talk about it. I mean, I think Mark Bryce said he closed out between 40 and 60 cases on average, right? So if you take the average of 50 and you just cut Judge Williams' caseload in half from the 636 and cut it in half to the 318, or if you take her numbers of 800 and cut it in half to the 400 because you want to assume that the JO is handling the other half of the cases, which I don't think you can assume. I mean, this is a little funny math, but at the end of the day, if you follow that math, the reality is that the 15 failure to rule complaints still account for less than 5% and less than 4% of her caseload. And again, going back to my quarterback analogy, if there's a quarterback on Sunday that has a 95, 96 completion rate, you're not going to say that that quarterback didn't do his or her job. What is also important is that after her tour of duty with the family division, you know, Division 3 went from the worst caseload to the second best caseload. All of those that context matters, right? Her numbers matter. It's not willful, and it's certainly not willful and persistence. And these are two categories under Rule 6 A in the JQC rules that warrant discipline. There are some other things that warrant discipline as well. We're not saying or suggesting that discipline is not warranted, and I'll get to that. But discipline is not warranted simply under these two grounds. You can't walk away and say that if you have less than 5%, less than 4%, depending on what the numbers are, or less than 3 or 2%, that somehow or another that is willfully and persistently neglecting your duties as an office. I want to, unless the panel has any other questions concerning the delayed rulings, I think I might add that, Judge Williams worked hard. In fact, there's evidence of that. I'm not saying she was the hardest working judge, but the reality is that she was one of the hardest working judges, if not the hardest working judge in Fulton County. She was in court. She was maintaining her schedules. And all of this happened a very difficult time when she experienced a lot of loss in 2023 and in 2024. And so she was not known to not work. She was not known not to be holding court. She was not known. She was known for some of the delays as were filed in the complaints. But at the end of the day, she worked hard. David Summerlin testified that at times, she would be the last vehicle in the courthouse. I want to talk about the improper arrest of Molly Dennis. Look, I think at the end of the day, whether you thought it was unclear or not, I thought it was clear from her testimony. And I reviewed the transcript on this. She acknowledged that what she did was wrong and that she didn't, and that it constituted an arrest, and that she didn't have the authority to do what she did. She acknowledged that on the first day of her testimony. And despite her well-intended motives, she testified that this would never happen again. And so I've got to talk about a little bit about the elephant in the room in this investigation, right? Because it keeps on becoming a recurring theme of the JQC operating with prosecutorial blinders, right? And so it was a one-sided investigation. And the reason why I say it's a one-sided investigation is because when this happens, you want to know what happened, and you also want to determine why it happened. Why it happened is just as important as what happened. And literally, there were witnesses there, parties and litigants there in the courtroom that the JQC refused to interview. They didn't think about interviewing them. They refused to interview them. And the reason why they refused is, I can only think of one reason, is that they don't really care about the why. I mean, you have to care about the why because the why makes all the difference in the world. And so, who did they fail to interview? Molly's dad and Molly's dad's lawyer. I mean, thankfully, Molly's dad's lawyer contacted me out of the blue after what he said, a hit from the AJC came out against Judge Williams, and he wanted to provide testimony on behalf of Judge Williams. He contacted me. I didn't contact him. That was his testimony. He reached out to me and said, look, that hit piece in the AJC is wrong. Judge Williams was trying to reach my daughter who was being manipulated by her mother. And what his testimony was very clear. And you heard his struggle as a father. Now, I will say that his testimony also kind of, if you will, dealt with the whole bickering between him and his ex-wife. But at the end of the day, when it came down to it and he started to hone in on the testimony of what Judge Williams did, he didn't see Judge Williams as having an ill motive. He saw Judge Williams as trying to help his daughter. And what he said is that if there was a 1% chance that what she did would reach my daughter, I'd have her do it again. Now, she knows that she's not going to do it again, and she testified that that would never happen, but that's pretty compelling testimony. And it goes to the intent of Judge Williams. Why wouldn't you want to know that? Why wouldn't you reach out to the parties? I mean, it's one thing, it's very easy to look and pull a cold transcript, right? And look at the transcript and see a violation. In this case, you see it very clearly. Take her into custody. You can see that that's a problem, and it happened during closing arguments. And at the time, there's no contention, there's no issue or dispute that Molly was not acting in a contemptuous manner. But ultimately, I mean, the temperature of that room is important, and why things happen is important. It doesn't excuse it. It doesn't mean that she had the authority to do what she did, but why is important. And so they didn't interview the lawyer. I mean, the lawyer testified, Molly's dad's lawyer testified that he thought that Molly was acting contemptuous during the proceeding. And then, frankly, I mean, based upon that contemptuous conduct during the proceeding, although she wasn't doing anything nefarious during the closing argument, when Judge Williams said take her into custody, he thought, she was authorized to do what she did. But at the end of the day, the why is important, is what I'm trying to get to. And then here's what I'm struggling with about the elephant, right? Is that Judge Williams then offers a public apology, and the JQC refuses to accept it. And in fact, indignantly, self-righteously, says don't do that. I had to object. I didn't even know what the legal basis of my objection was, other than it just sounded argumentative. What? And it calls into question, it begs the question, what are we doing here? That the JQC, that the director of the JQC would instruct the judge to not apologize to someone who at some point, based upon the judge's conduct, was adversely impacted? Don't apologize. Why would that ever come out of the JQC's mouth? Why would you ever take that position? Because their mind was made up. Removal has always been what the investigative panel wanted. But let me tell you what Molly testified to when asked by Attorney McFadden. Question. So a part of what Judge Williams said in her testimony was that she apologized for the impact that she caused you to you in sending you to the cell. Did you know that? I did not know. Does it matter to you that Judge Williams apologized? Yeah, I am glad that she apologized and came around on that for sure. I mean, I feel as Christians, you know, it's our job to forgive and to try to live like that. And I know she brought up Bible verses, so she's a believer too. So yeah, I think that we all should, if everyone was like that, the world would be a much better place for sure. I got to tell you, when Molly, very young, impressionable young lady, said that, and you juxtapose that position to the director's position in demanding that the judge not apologize to Molly, it begs the question, what the hell are we doing here? Are you really trying to figure out if this is an unfit judge? Do you really care why she acted the way she acted? Are you really interested in whether or not she has any redeeming qualities? That the young lady that was impacted by this improper arrest was willing to accept her apology and forgive her, but the director of the JQC said, don't even worry about it. Don't apologize. Now, what was her intent? If you remember the testimony of Mark Bryce, the JO that testified, he talked about the judicial philosophy that Judge Williams maintained, particularly in child custody cases. And he cited a quote that Judge shared with him during his time as her JO. Never let the sword of a parent be stained with the blood of the child. And since the director didn't want to know, I'll tell her now, but her intent by doing what she did was to try to stop the hemorrhaging. She saw a child that we see often in custody cases being used as a pawn, and she saw Molly's blood on her mother's sword. And she saw Molly acting out in ways that she was trying to reach a wayward child in hopes to get her attention. That is so remarkably important in this hearing panel's consideration. In fact, I think it was you, Commissioner Hyde, who indicated, I don't question your intent, but essentially, you didn't have the authority to do what you did. Her intent was not ill-gotten, was not malicious, was not evil. She wasn't trying to punish Molly. She was trying to wake Molly up and let Molly know that if she continued along the course that is consistent with the manner in which she testified, that Molly might find herself in a jail cell. And getting back to Molly's dad, if it had a 1% chance of reaching his daughter, I mean, he indicated that he would want it done again. And look, so intent matters. I know you may have some questions and I'm happy to answer those questions.
I'll defer to my colleagues.
I thought we were waiting until both of them got through, but
We are.
okay.
All right.
I can save mine for when
Okay.
the director's done.
But despite her well-meaning intention, Judge Williams testified that, look, I know what I did was wrong. I didn't have the authority to do it. And she agrees that discipline is warranted. Let's talk about the call on behalf of the uncle. She testified that she should have never made the call. You remember the facts of this case that she had just gotten out of trial at some point, although she didn't remember that she was actually in trial. She was tending to her grandmother, who was essentially on her deathbed. And at some point, I think it's important to note out that about 5 or 6 months earlier, her mother passed away, and the torch passed to Judge Williams. And so at some point when some papers were served upon her uncle, Judge Williams was handed the papers, and it dealt with some type of case involving him and his benefits, and the time was about to expire, and Judge Williams counseled her uncle and ultimately indicated that he needed to request an extension. And against her better judgment, she made the call. You juxtaposed Don Smith's testimony to Judge Williams' testimony concerning the Sorer comment. I will say this. I mean, I asked Judge Williams when Bonnie Stinson testified if you heard or recalled her testifying about you arguing the merits of the case, and in fact, you saying that if this case came in front of me, I would dismiss it. And Judge Williams acknowledged that Ms. Stinson's version of events and testimony, that she had no reason she had no reason not to believe Ms. Stinson, or had any reason to believe that Ms. Stinson was lying about it when she testified. And I think it's important. And so, look, I will say a couple of things about the comment concerning dismissal. When she was first asked that question by Director Veal, it came out of nowhere. It's not in discovery. Unlike the Brandy Alexander complaint, it's not alleged in the complaint. That comment about, if this case comes in front of me, I'll dismiss it. And my recollection of her testimony is when asked that initially, she said, look, I didn't say that. And then when she heard Bonnie Stinson, and I asked her again when I put her back on the stand, look, you heard Bonnie Stinson say you say that. Look, I have no reason to believe that she's lying. It's a very emotional time for me. If that's what I said, that's what I said. I accept that to be true. And so that gets back to the fairness of the proceedings, right? It's a setup question. While she was on the stand, I heard it, and I was like, I've never heard that before. I've read every piece of paper in the discovery that was provided by the JQC. Why wouldn't you allege that important fact? We don't have a single report from Bonnie Stinson. We don't have a memorialized report from the investigator or from the director about what Bonnie Stinson said. And so we heard that from the first time out of her mouth when she took the stand. And then ultimately, she asked Judge Williams about it, and Judge Williams had never been asked about it before, and then ultimately didn't recall saying that. And then finally, when Bonnie Stinson testified, and then I put Judge Williams back on the scene or on the stand, Judge Williams acknowledged, hey, if that's what Bonnie said, I don't have any reason to believe that she's telling a lie or being dishonest. And so that's not enough to create a credibility issue here. Simply not enough, particularly when you've never, ever alleged it. It just comes out of nowhere. Everybody's presumed to tell the truth, but, I mean, how do you ask somebody about a conversation and expect them to know and remember everything down the road? And it's just when Judge Williams was initially asked, in her heart of hearts, she did not believe that she said that during the conversation with Ms. Stinson. She acknowledged, in any event, that she played a part in the uncle's email that was sent to Miss Stinson. She dictated it to her uncle. She told her uncle what to say. And ultimately, she indicated that it would never happen again. And she's also acknowledged that the impact of her mere role as a judge may have on people, and how someone as a judge calling a lawyer to a case, even though that judge is not presiding over the case, whether you say I'm not calling in my judicial capacity, she's acknowledged how that may play a role in that lawyer's mind, and how that might pressure the lawyer. She's acknowledged that when she testified. And according to Judge Williams, she's established appropriate boundaries. And I've talked about the elephants already. In this case, I know that at some point, Judge Burleson, you raised the issue of the email. And the fact that in the subject line, the email reflected forward, right? And so I have to address it. The JQC failed to interview critical witnesses or even try to put them on the stand. They had the opportunity to do it. The one critical witness that they never talked to is her uncle. They could have called him up. They could have talked to him. The other thing that they failed to do during this case is they could have obtained the emails. They could have obtained or subpoenaed the uncle's emails and or Judge Williams' emails. And while raising an eyebrow is fair at the forwarding in the subject line, by clear and convincing evidence, when Judge Williams says that, hey, I did not forward that email to him, I didn't write the email, I didn't type the email, I told him what to say. Judge Williams also testified that her uncle was very smart, that, he was married to an educator, and we don't know for all intents and purposes whether the uncle's wife typed the email from her email and then forwarded it to the uncle. I say all that to say is this. When you're talking about the clear standard of clear and convincing evidence, more needed to be done than to simply introduce an email that reflected forwarding. That by itself does not reflect that Judge Williams forwarded that email to her uncle. And why not just acknowledge it? She's acknowledged that she told him to say exactly what was in the email. Talked about the dismissal. This thing about the email, the thing about Bonnie Stinson, it cannot establish that she has been less than candid. It simply can't. So we're not suggesting that discipline is not warranted in this case, but removal is not warranted, and that's what the JQC wants in this case. So I want to talk about discipline and sanctions at this point in time, because the hearing panel sent off questions and ultimately asked us to compare other cases and what the JQC and the hearing panel and the Supreme Court has done in other similarly situated cases. And as you know from Rule 6A, grounds for discipline, the conduct has to be willful misconduct, or it has to be willful and persistent failure to perform the duties. 3 and 4 really don't apply because we're not talking about intemperance. We're not talking about conviction of a crime. But the 5th component is conduct prejudicial to the administration of justice, which brings the judicial office in disrepute. Type B just deals with the type of sanctions. You can remove her, you can suspend her, you can impose, the Supreme Court can impose limitations on the performance of certain duties. You can publicly reprimand her. There can be a private admonition, or there can be other appropriate disciplinary actions. And so I want to first say, before I get into this,
Well, number 6 is out.
number 6 is out. I'm sorry.
We don't do that.
That's right. It is out. I should have struck that as well. Before I talk about the comparisons that the hearing panel inquired, my intent is to address the hearing panel's questions. I am not in any way trying to bring up old news for judges who have been before the JQC or disparage their character or bring up old
No, that's
trauma.
what I'm doing.
I got you. And so let's just start with a judge who survived removal for his conduct. He was a magistrate judge in Crawford County. He actually assaulted a defendant, committed a crime. Now, he was never charged with the crime, but nonetheless, he assaulted a defendant after a court proceedings. He was on the bench. There was an exchange between him and the defendant inside the courtroom. After the proceeding, the judge left the bench, and followed him out into the hallway and physically assaulted a defendant who was shackled. That judge is still on the bench. That judge is still on the bench. And in that case, that judge, and we're not talking about a crime here, Judge Williams' case, that judge committed a crime and is still on the bench and got a 30-day suspension and a public reprimand. And so we can just stop right there, because when you compare that case to Judge Williams' case, there's no comparison. She has not committed a crime, and that judge did. And we're not talking about a DUI, right, that may have been the result of a substance abuse problem. We're not talking about that. We're talking about physically assaulting an inmate who was shackled. 30-day suspension and a public reprimand. And that was agreed upon. And the Supreme Court approved it. A Cobb County judge survived removal for his misconduct. And this involved this judge engaging in actually inappropriate ex parte communications.
What? Remind me what case that was.
It was a while ago, and unfortunately, this judge is no longer with us, and so I'm not trying to talk ill of the dead, but it involved a judge who served as a Superior Court in Cobb County.
Okay.
And it was very public in 2016. And I'll tell you, there were prosecutors in that case, and I mean, the director should be very familiar with this case because she was one of the prosecutors who engaged in the inappropriate ex parte communications with that judge while then serving as a prosecutor.
Mr. Banks, I do want to
Yes,
make a distinction. None of these folks came through the hearing panel.
that is true.
Okay.
Which
I
is
just wanna make sure. The hearing panel was not involved in any of the sanctions or recommendations.
Not these two. The hearing panel was involved in another one that I'll mention, but on these two, that is a remarkable distinction, and I think it's worthy of note because the question is why. These conversations, which were recorded, they happened inside the courtroom. They were deemed to be substantive in nature. Substantive ex parte communications with...
So I'm going to object. I've not objected for long enough. This entire matter is completely confidential, and what he is stating to the hearing panel is
Public
incorrect. It is inaccurate. They were not substantiated. It was dismissed by the investigative panel. You have referenced me. I was in that courtroom. You know a bar complaint was filed against me, and it was dismissed.
Okay.
So I think we should move along from this case.
Well, you're not going to tell me how to move along.
Okay.
I'm asking the
Hang
hearing
on a
panel
minute.
to-
There's an objection on the floor. What is the legal basis of your objection, Ms. Field?
relevance.
Okay. Mr. Banks,
This hearing
response.
panel asked me to come up with comparisons, whether it's a private matter or not. The reality is that this was a public spectacle in 2016 that involved ex parte communications, JQC complaints were filed, and the question is why were they dealt with privately?
Okay. Well, I overruled the objection, but I'll say this to Commissioner Lopez's point. I mean, these are helpful in sort of the universe of charges that have occurred, but I feel relatively confident in saying that had at least the previous one we discussed a moment ago come before this hearing panel, there would have probably been a very different outcome for that judge in Crawford County. And so, I mean, this is helpful discourse, but I think what would be even more helpful for us is the apples to apples, which is
Okay.
the one you've just gone to, which
Well-
is where folks who came in front of, for a
Sure.
full-fledged trial in front of the hearing panel.
Yeah. An Athens Clark County judge survived removal for his misconduct. In 2019, that judge actually made some rulings about an individual who was charged with rape, and there was a mistrial, and then that judge let the individual out on bond. And after that happened, a bail bondsman was publicly, very public about criticisms of what that judge did. And so, and the judge became aware of the public criticisms, and what did he do? He reached out to individuals who knew that bail bondsman to get that person's number. And eventually got the number, and they began, the judge and the bail bondsman exchanged some text messages where the judge ordered him to come to the chambers the following morning. When he got there, the bail bondsman, he came with two of his friends, and the judge ordered him into chambers, but before doing that, there was an armed deputy with the sheriff's department that took all of the cell phones from all three of those individuals. And at some point, the bail bondsman was ordered inside the individual suite of that chambers and ordered to sit down while the armed deputy stood in between the door, as the judge, for at least 30 minutes, berated that bail bondsman about his conduct and his comments. Told him to sit down and listen to what he had to say. The opinion reflects that the judge's lip was quivering and his hands were shaking and that he was clearly angry. Importantly, the bail bondsman asked for a lawyer. Judge ignored the request, according to the opinion. Ignored it, but allowed his friends to come back in, but still made him sit there for 30 minutes while the judge lectured him about how he felt about the bail bondsman's conduct. That bondsman felt and testified that he was not free to leave. The judge chastised him for 30 minutes, during which time the judge implied that the bail bondsman didn't have good moral character, that he was spreading fake news. He also implied that the judge had power to affect his livelihood. After that incident, a JQC complaint was filed. And before it even got to the panel, the JQC investigative panel at that time and the judge had entered into a discipline by consent that they presented to the Supreme Court. The Supreme Court rejected it. Wasn't good enough. There was a contested hearing, and at the conclusion of that hearing, the JQC made a recommendation of a public reprimand. A public reprimand. This is really akin to the Molly Denson situation. I mean, it's really all on fours. I mean, if you want to think about it, but there is an important distinguishing fact that you should consider. Either way, the JQC made a recommendation of a public reprimand. The hearing panel at that time, not this hearing panel, but the hearing panel at that time, rejected that recommendation and simply said, hey, you ought to publicly apologize. The Supreme Court rejected the public apology. In so doing, they held that there was really no precedent for it. I mean, under those provisions, there's other disciplinary actions that the hearing panel can recommend But what the Supreme Court said is that even though that is an option, and you can engage in other disciplines, that other discipline still has to have precedent. And there was no legal precedent for a public apology, and as a result, the Supreme Court imposed a public reprimand. No suspension, but a public reprimand. And the reason why I say the facts are akin to this case is because while that bail bondsman was not handcuffed, he had an armed deputy standing in front of that door, and he wasn't free to leave. And what's important is that what is important about that case is this, is that at some point, the hearing panel in that case, when they sent up their recommendation for a public apology, the Supreme Court noted that the hearing panel did not find credible that judge's explanation of why the meeting with the bail bondsman occurred. Did not find him credible. But nonetheless, notwithstanding that issue of credibility that the Supreme Court said the hearing panel took issue with, didn't find his purpose of the meeting or the reasons that he provided for the meeting as credible, he got a public reprimand. And let me tell you something, why this case is on all fours, but there is one glaring fact that is different. It goes back to intent. It goes back to intent, something that, at least in this case, the JQC was not interested in as to why Judge Williams did what she did. In this case, when you read the record and you read the opinion, it is crystal clear that this judge was mad as hell at this bail bondsman and had an issue and a bone to pick, and ordered him to chambers and required him to sit there and ultimately listen to what the judge had to say for 30 minutes. And he wasn't free to leave. He asked for his lawyer. That was never granted. While his friends were permitted to come in and join the meeting, the reality is that he was chastised by a judge for 30 minutes. And ultimately, he got a public reprimand, not a suspension, not a private reprimand, not a public apology, but a public reprimand.
Mr. Banks, you're significantly over your 1 hour.
Okay. I'm almost done.
So I would say next 5 minutes, please. 'Cause
Okay.
We've given
I got you.
We've given you.
I appreciate it.
And at this point now, you're starting to repeat yourself a little bit. So
Okay.
okay.
I appreciate it. All right. So look, intent matters. And with Judge Williams, I will just say this, is that her intent was not to harm Molly. Her intent was not to pick a bone with Molly. Her intent was to reach a wayward child, and that is far different than the intent of the Athens-Clarke County judge.
Well, the Athens judge, couldn't you say there was time for the voice of reason to intercede? There were several days between whatever happened and the judge having this bondsman come to us, whereas the respondent made a decision as it's going on. Judge Williams had minutes to decide what to do, whereas the judge in Athens had a week or so.
Which makes it even more egregious for the Athens judge. There's another municipal court judge. There were issues of habitual tardiness, excessive absences, a failure to allow multiple defendants their day in court, extending their time in jail. That was a consent by discipline. Ultimately, the consent by discipline recommended a public reprimand, and on the outlier, there was a 90-day suspension. A judge in Emmanuel County. And the reason why I bring this up is because some of the conduct has nothing to do with Judge Williams, but I will say that there is some conduct that has something to do with Judge Williams. But the reason I bring this up is because this judge engaged in misconduct for a 7-year period, a seasoned judge, 7 years period. And the conduct that's connected to this in some respect is that this judge was calling the solicitor and calling another judge to try to influence charges on cases on behalf of individuals who he knew to be friends. And that lasted for 7 years. He got a discipline by consent, 30-day suspension, and a public reprimand. So, look, the range, if you accept the one that was private, is private reprimand up to a 30-day suspension on these cases. The mitigating factors that this hearing panel should consider. There's a lack of prior disciplinary history. She has none. Not as a lawyer, not as a judge. She's acknowledged her misconduct, with the exception of the Brandy Alexander case, which she should contest. She's taken corrective actions to resolve her missteps and her misconduct. That's true as it relates to the failures to rule or the delayed rulings. That's true as it relates to the calls that she made on behalf of the call she made on behalf of her uncle, and that's also true as it concerns Molly Dennis. She is a young judge and was, like any judge, going through the pains of being a young judge and just trying to figure it out. She publicly apologized to the litigants and the parties and has demonstrated genuine remorse. She expressed a willingness and a desire to learn more and has taken CLEs consistent with that desire and has made a commitment to not engage in further conduct. She had some very personal family circumstances, particularly around the delayed rulings, that impacted her severely. You know, her mom had a bout with cancer. Prior to her mom expiring, her uncle died. A few months later, her mom died, and then a few months later, her grandmother died. Those are all very trying personal family circumstances, but I asked Judge Williams specifically, hey, if these situations come up again, how do we trust that you don't engage in this misconduct? And she says, I've just put the appropriate boundaries in place. She sought out mentorship. She not only mentors younger lawyers, but she sought out mentorship for advice and counsel. She's actively involved in the community. She gets support from the legal community and the lay community, and ultimately she was reelected by the citizens of Fulton County. I will just say that there are two witnesses, Attorney Pennywell and the father, Molly's father, who indicated that, look, if this panel doesn't remove her, but simply elects to discipline her, and there's another election, that they plan on re-electing Judge Williams and casting their vote for her. So I'm done here, but I will just say this and close. You know, the federal sentencing guidelines in criminal cases has absolutely nothing to do with this case, but it is instructive concerning this hearing panel's mission. And then the guidelines used to be mandatory. They are now voluntary. And the judges can do what they want to do, and the language that the courts now use is that a judge's job is to impose a sentence that is sufficient but not greater than necessary. Because in doing that, it acknowledges that punishment at times is necessary, and it also acknowledges at times that punishment should not be unduly harsh, nor exceed what is required to achieve the goals of the legal system. Judge Williams is a bright, young judge who is very talented. And ultimately, this hearing panel, if it does what is sufficient but not greater than necessary, the only conclusion that you can reach is something short of removal. I would recommend on behalf of Judge Williams that you recommend a private reprimand up to and including a suspension of no greater than 30 days. So, unless the panel has any other questions, I apologize for extending my time. I don't know if I need to check with my team, if I need to say anything else, but on behalf of Judge Williams, I'd be remiss if I didn't thank you. You guys have been an active panel. Thank you for your commitment to this important body of work, and I appreciate your time and attention.
Thank you, Mr. Banks. Why don't we take a 15-minute recess before we start with the director's closing argument? So we will start back, let's call it 11:15. 11:15. and writing stuff down. Would either of you be willing to share them with the hearing panel afterward? Thank you. Okay, great. All right, are we ready? All right, just a reminder, if you did happen to use your cell phone during the break, please make sure it's silent, volumes turned down, etc. All right, Ms. Veal, when you are ready.
Why are we here? It's a question that was asked a few times in the respondent's closing argument. But it was asked in a way from that side as if, or to suggest that we're here for no reason and that all of this has been for naught. This trial, unfortunately, has turned into an attack on a whole lot of people involved with the process or witnesses to this process. But this trial is about a judge who, beginning early on in her judicial tenure, began violating the Code of Judicial Conduct, and over and over and over again continued to violate it. And she continued to do so, knowing that she was under investigation by the JQC, knowing that the JQC was going to be looking at her conduct. And what the hearing panel heard during the days of testimony and today during closing argument was an excuse or an explanation for nearly every count in each of the sets of formal charges. But one of the things that I would ask the panel to consider as you're wading through those excuses and those explanations is, and the one that stands out the most right now is Molly Dennis. And the explanation is, I was well-intentioned and I was trying to save a young girl who was going down the wrong path. Oh, and I wanted to apologize, but the director said, please don't, when I said it in court. Judge Williams illegally jailed Molly Dennis in October of 2023. The charges related to that jailing were not filed until February of 2025. So all that time in between, we didn't get a self-report. We didn't hear an I'm sorry. It was only until Judge Williams was called on her misconduct and came in here and took the witness stand and realized, I have to get right before this panel because I've illegally jailed somebody, so I have to say something. It was only then that the explanation came about. And I would ask you to consider that in the context of all of her other violations. We are here because this is a judge that violates the code repeatedly, and by the way, a smart judge. We heard a whole lot about her educational history. She went to great schools. We heard a whole lot about her experience prior to taking the Superior Court bench. We heard a whole lot about her trial work, and I would submit to the panel that in many ways, her intelligence, and you saw her testify, she's incredibly smart, but her intelligence and her experience makes so much of this worse. Right? If the judge sitting up here were a non-lawyer probate judge down from South Georgia, yes, the jailing would still be bad. And yes, the phone call would be horrendous and the delays, and it would be bad. But there's something about a non-lawyer judge sitting up there and somebody that doesn't have the training or the experience and just truly doesn't know better. That is not her, right? She knows better. She's smart enough to figure it out in any instance that she didn't. And the truth about her is that it never mattered that she was under investigation by the JQC. That started in February of 2022. That never mattered to her because the behavior did not change. She repeatedly violated the code over and over and over again. You have multiple notice letters in front of you that went to Judge Williams during the course of this investigation. Over and over and over, I'm under investigation by the JQC and nothing changes. And so I would ask the panel to consider that as you're wading through this case. I would also note that contained in the Code of Judicial Conduct is this, and this is found at the very beginning in the preamble of the code. The code is not intended as an exhaustive guide for judges and judicial candidates. Judges and judicial candidates should also be governed in their professional and personal conduct by general ethical standards. They should strive to achieve the highest ethical standards, even if not required by the code. The mandatory provisions of the canons and rules describe the basic, minimal ethical requirements that should govern the behavior of all judges and judicial candidates. So these rules are the basic requirements. It is not wrong for the investigative panel, for the hearing panel, and for the Supreme Court of Georgia to expect far better than what we have seen on behalf of this judge. Here are the factors for discipline that are set forth they are both contained in the Code of Judicial Conduct as well as the rules of the JQC. And those are when both the investigative panel and the hearing panel are determining discipline. When there's been a determination made that discipline is warranted, factors should be considered, such as the seriousness of the transgressions, whether there is a pattern of improper activity, and the effect of the improper activity on others or on the judicial system. I'm going to jump around a little bit in the formal charges, so forgive me in advance, but the way I've presented them is for a reason. And so I want to start with the 25 set of formal charges and the Molly Dennis complaint. I know the panel has the transcripts and set through days of testimony, and so I'm not going to rehash the factual bases for each of these counts. I am happy to answer questions on each of them. However, I am going to touch on all of them. So these are the counts contained in the formal charges that relate to the Molly Dennis jailing. Count 1 is the failure to respect and comply with the law. Count 2 is a failure to act in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary. And count 3 is 2.8b, a failure to be patient, dignified, and courteous, and to a witness that was before her, and that's what Molly was in this context. And so, as you'll note, I don't normally have a lot of question marks in my closing arguments, but I do here, and I have those there because these 3 counts are the ones that Judge Williams now admits. What I am going to ask the hearing panel to do is to truly consider, and these counts are a set of counts that relate back to the facts as alleged earlier on in the formal charges, so the paragraphs in the charges, whether or not there has been a true admission. If you recall, as when Judge Williams took the stand for a second time in her case, when I attempted to ask about what she admitted to, it became incredibly difficult. We had to halt the proceeding. And so, again, I understand there's been I admit certain things, but I don't like the wording. The wording is what it is. The investigative panel directed me to file the charges, and that's the wording that we came up with, and that's what's there. To me, this is pretty black and white. You admit or you deny. But I would ask the panel to consider, again, this happened in the middle of this hearing, by the way. It was not something that we agreed to in advance. It was in the middle of the hearing after witnesses began to testify, and so I would ask the panel to consider that. I would also ask the panel, I believe that I admitted an excerpt of the transcript from that hearing. And I admitted the excerpt to focus the panel in on the interaction with Molly and the illegal jailing of Molly. But there is a full transcript, by the way, that the investigative panel, during the course of the investigation, the complaint came in, and the investigative panel had that entire transcript. But you have the entire transcript, and so Judge Williams' team wants to remind you all that context matters, and it does, but one can read the transcript and take from the transcript the fact that Judge Williams obviously thought that she was conducting some kind of like scared straight program, right? You can gather that from the speech that she gives Molly after she pulls her out of the holding cell, and the first thing she says to her is, "How was that for you?" She then gives her the whole speech, accuses her of having daddy issues, and tells her a whole lot of things that are, in my view, not helpful and certainly not appropriate. But I would ask the panel again, if the intent of the judge, and I'm not suggesting that this is the proper role of a judge, I have seen judges speak to youthful offenders, witnesses, other people in their courtroom. When they feel like there's conduct or something that needs to be addressed, you have to do so carefully. But I would ask if her desire was truly just, I see this girl in front of me, by the way, she's an adult, right? She's 21 years old. This is not a teenager or a child, but I see this girl in front of me. She's in the midst of her parents' divorce proceeding. It's a nasty proceeding. She's doing things in the back that I don't care for, and I want to address her and her behavior. She could have easily addressed her, right? After closing arguments or whenever, sometime after she's done on the witness stand. She could have said those things in that speech that she said. The jailing piece was, and to use the judge's words when I asked her about it, it was for shock value. She wanted to scare her. She did not like how she was behaving. She wanted to embarrass her, and she wanted to scare her. And I understand. She then brings her out. How was that for you? And you can recall the way that Molly described it, if you can imagine as a 21-year-old being thrown back into a jail cell for what reason, you don't know. But she then says the things that, perhaps, and I understand what they're trying to say. It was just all out of concern. She just really wanted to help her. She could have done that without throwing her in the back of that cell, right? She could have done all of that and accomplished it without the jailing. And so I would ask that the panel consider that about the Molly Dennis issue. So the grounds for discipline, what I did with my closing, I have woven in some of the panel's questions and issues that I think relate to those questions into my closing instead of just touching on them afterward. But I think the grounds for discipline piece of all of this is incredibly important. We saw that manifest in Coomer and then in subsequent cases as well. And so I have laid out the grounds for discipline as to each complaint and issue to make it easy in my closing and easy for the panel to go through. So the jailing of Molly Dennis, the counts 1, 2, and 3 that relate to her constitute willful misconduct in office as well as conduct prejudicial to the administration of justice, which brings the judicial office into disrepute. And again, these are the constitutional grounds for discipline found in our Constitution as well as the JQC's rules. And what our Supreme Court has said, and I think it was said most clearly in the recent Christian Coomer cases, is that in order for a violation of the code to warrant discipline on the ground that it was willful misconduct in office, they have to be actions taken in bad faith by the judge acting in her judicial capacity. There is a definition, or the Supreme Court's definition of bad faith in this context is set forth in Coomer 1 as well as Peterson. And it says that bad faith is more than negligence. It is a breach of a known duty through some motive of self-interest or ill will. So if we do not believe that there is bad faith that exists for the counts that relate to the illegal jailing, then we get to conduct prejudicial to the administration of justice, which brings the judicial office into disrepute. In order to constitute discipline or warrant discipline on that ground, the actions have to be inappropriate actions taken in good faith by the judge acting in her judicial capacity, but which may appear to be unjudicial and harmful to the public's esteem of the judiciary. And again, that definition is found in Coomer 1 and Peterson, and you will see throughout my closing as I'm going through the grounds that oftentimes conduct prejudicial to the administration of justice, which brings the office into disrepute, is the ground that I'm going to advance as the one that for which discipline is warranted. Complaint 24-960. This is the phone call to the uncle. Once again, That is a more recent event that occurred in 2024. And I understand what is being said and what Judge Williams has offered as excuse and explanation for what was going on. It's that I was having a very difficult time in my life, which every person in this room has experienced death and cancer and loss. I don't mean to take from it, but I believe Mr. Hyde raised this during the course of the proceeding, and that's every single person goes through those things. And there are certain expectations of judicial officers that do not go away because they are going through a difficult time in their lives. These two counts, again, the call to the uncle, she's charged with violating 1.2B, which is failure to maintain and enforce high standards of conduct so that the independence, integrity, and impartiality of the judiciary is preserved. And count 1.3, lending the prestige of office to advance the private interests of another. I believe with the new admissions here today, she has admitted those things. Again, I would ask the panel to consider what is alleged in the paragraphs, what was proven during the course of the proceeding with Ms. Stinson's testimony. And so there are a few things that stand out to me, of course, and it's Ms. Stinson's testimony that Judge Williams pretty immediately delved into arguing the merits of the case. Judge Williams asked her for an extension of time within which the uncle could file the answer, and also the comment about if this case came before me, I would dismiss it. Let's start with that one, since that's been a big part of the defense of that piece of this. So the way the JQC process works, to Mr. Hyde's point, is that if there are written memos or documentation of witness interviews, that does not necessarily make them disclosable, but oftentimes there are not written written witness memos or interviews for us to turn over, right? This is a regulatory proceeding. The GBI or the investigative panel staff is not the GBI, right? And so yes, there are witnesses that we did not interview, and yes, in this context, there were witnesses that we did not interview. However, every single witness that was identified on the witness list, according to our rules, is somebody that can be deposed in advance of the hearing. And so for any lawyer that comes in and argues to the hearing panel, what they said on the stand, that was the first time I heard it. Well, in this context, that's their fault, because there is a way in which we can depose these witnesses. And I will say, speaking from my experience, I was also a prosecutor for several years. It was often that there were witnesses that were witnesses for the state that did not wish to speak to the defense, not because they were trying to hide something, not because they were trying to be difficult, but that they didn't want to, right? I think that sometimes we have to step out of our lawyer experiences and place ourselves into the position of some of the lay witnesses and people that get involved in any proceeding, not just this proceeding. This kind of proceeding is special. But what I saw as a prosecutor is that there was just a general level of discomfort with, I am uncomfortable with the fact that I am a witness for the state in this proceeding. Granted, there were some witnesses that were thrilled. They loved it. When can I testify? I'm going to wear my best outfit. Can't wait to take them out. Most people don't want to be involved, right? And so there's discomfort with talking to the other side. It's their lawyer. I don't know what they're going to ask me. And so often that is a response that I see. There were times when I was a prosecutor, I would call people on the defense's witness list. I don't want to talk to you. Fine. And so to suggest that there's something abnormal about that, I think is a tinge disingenuous. Now, Mr. Banks suggested it's a member of the bar, and I guess that piece of it, he suggests, makes it a situation where Ms. Smith should have been more willing to talk. Again, I think we've got to step outside of this experience for ourselves. All of you all have been appointed to this commission. You have a very difficult job to do. The people that work on the investigative panel, staff applied for and sought these jobs. We also have a difficult job to do. But for most people, They do not want to be involved in JQC proceedings. It is like pulling teeth to get them to talk, right? And so for most people, just again, stepping out of ourselves and our perceptions and what might I do, there is a high level of discomfort for anybody involved in these proceedings. Lawyers, lay people. I am testifying against a sitting judge, right? I've become a witness in this matter. And so, again, to suggest, I guess, like a bias or perhaps that there's a credibility issue in not wanting to talk, I think is a little disingenuous. But back to the phone call. Again, I think that these are two counts that Judge Williams has now said that she admits. I would ask the panel to carefully review the allegations and the testimony, and also to consider that Judge Williams testified twice about this phone call. The first time she testified to it, I would ask the panel to pay very close attention to her answers in response to questions specifically related to arguing the merits of the case, whether or not she asked for an extension, and whether she mentioned that if the matter came before her, she would dismiss it. And I think you will find, once again, from a very intelligent jurist who oftentimes did not have any difficulty answering questions about things that happened 4 or 5 years ago in significant detail, you will find, I don't know, I don't recall, I don't know, or I don't recall that, specifically related to what happened during this phone call. And again, the idea that, well, we didn't know what Ms. Stinson was going to say, or we didn't know she was going to say that about, the case being dismissed. If it were in Judge Williams' courtroom, Judge Williams was on the phone call. She should be able to tell us every single thing that was said on that call. And again, I'd ask that you compare her memory as she testified in her first round of testimony to that phone call to her memory for different things that she was able to testify to in detail from 2021 and 2022. I would note the email from the uncle became an issue that the panel members asked several questions about, certainly one that I called attention to, but there is not a charge that relates directly to that email in the formal charges. So again, there was some reference in respondents' closing about not proving something related to that email. I think that email is just an issue or a surrounding circumstance to be considered by the panel at this point. That is not something that is contained in either of the charges at issue for that phone call. I pulled just a piece of Ms. Stinson's testimony for the panel to consider. And just to refresh the panel's recollection of what she said, she immediately got into the merits of the case. She started to discuss the underlying issues. I asked her if she was representing him because she immediately started talking about the merits of the case. She began advocating for her uncle. She mentioned that if this case had gone in front of her, she would have dismissed it, that there doesn't seem to be any benefits available, and we should just figure a way to make this all go away, and that I was a reasonable attorney. Attorneys at my firm were known to be reasonable attorneys, and there should be a way that we could just figure that out instead of having the case go forward. I would ask the panel to consider a brand new lawyer being on the receiving end of a phone call like this from a judge that has a case or cases from her firm pending in front of her at the time. I understand Judge Williams testified that she didn't know about that. This is Patricia Shoemaker's firm, that firm, that family law firm, likely at any time long before Judge Williams took the bench in the family division through now, has cases pending in front of the judges in the family law division, right? And, again, so a new attorney being on the receiving end of a phone call like this from a superior court judge, I cannot imagine something much more uncomfortable, right, than a judge calling me up and wanting to argue the merits of a case that is pending where I am involved in the representation of the opposing party. And I would ask the panel to consider the why, right? I mean, she was operating out of self-interest. I'm going to make this phone call to benefit my uncle. And again, this violation, this complaint is the most recent contained in the formal charges. And so at the time Judge Williams picks up the phone and does this, she has gotten multiple, over the last 2 years, multiple notices from the JQC investigative panel. She's come into a meeting, she's made a statement, she knows that we have had to haul witnesses into a meeting to make a statement. We've had to send her multiple pieces of correspondence related to her delayed rulings. You are under a microscope. You're under a microscope, and this is what you choose to do. I understand that, it was just my family was going through a lot and we lost somebody, and that is sad and it is unfortunate. But this kind of conduct, you can't train or educate this out of any judge. You don't train or fix this, right? She did this because she could, and she thought that she would get away with it. This is that simple, right? And you know, again, to brush it aside or you know, it was just a lapse in judgment. This is very serious, and I'm going to compare it to some of our other prior disciplinary cases that are relevant to this case toward the end of my closing argument. Grounds for discipline. So, as we learned in the Coomer matter, when a judge acts outside of their judicial capacity. So I'm a judge, but the act at issue is a non-judge act. The only available ground for discipline in that circumstance is conduct prejudicial to the administration of justice, which brings the judicial office into disrepute. That's the only ground available when we have a judge acting outside of their judicial capacity. What Coomer and Peterson both told us is that in this circumstance, this is another circumstance where bad faith is required. So the hearing panel has to find that she acted in bad faith in this circumstance in order for these violations, the call to the uncle, to warrant discipline. Again, bad faith is more than negligence. It is a breach of a known duty through some motive of self-interest or ill will. Bad faith is not simply bad judgment or negligence, but it imports a dishonest purpose or some moral issue, right? There is a dishonest, like I am doing this for a dishonest purpose or a selfish or self-interested reason, and that is what we have here. The self-interest was helping out her uncle, right? It doesn't have to be just her helping herself, but it is making a phone call and attempting to do something to help a member of her family. And so I would submit to the panel that we clearly have the evidence to prove those violations, which, by the way, the clear and convincing standard is an interesting one in what I find in the case law when I look it up and try to find a definition. And obviously, it is more than a preponderance of the evidence, but less than beyond a reasonable doubt. And our appellate courts in the state have said it means a high capability. The evidence has a high capability of inducing belief. That is what clear and convincing evidence, according to our appellate courts, is. So once we've proven by clear and convincing evidence the violations, then we have to demonstrate bad faith in this context in order for it to warrant discipline. And I would submit the evidence as to the phone call with the uncle meets what is required here. So the one case in the judicial discipline space that was not mentioned by the respondent in closing, that is the most similar to this case in many ways, is inquiry concerning Judge Christina Peterson. Two of our panelists sat on the hearing for that case, and so I know that they are familiar with it, but Judge Burleson, you did not. And it is similar in a number of ways. One of those ways is that in that case, and I think I argued it in my closing, none of former Judge Peterson's violations alone or in and of themselves would have been sufficient for her removal. And so essentially,
I disagree, but go ahead.
well, perhaps the jailing would have been essential for her removal, according to Mr. Hyde, but that's what I argued. She won the election in 2020, took the bench in January of 2021. She was a younger jurist, went to good law schools, had prosecutorial experience and civil experience. So she was an experienced lawyer when she took the bench. One of the things, or one of Judge Peterson's issues, one of the complaints with her was conduct as a judge outside of her judicial capacity. And Mr. Hyde and Mr. Lopez will probably remember, because there was audio of it. She went to her neighborhood HOA meeting and got into it with some of the other members there of the HOA, but at issue in the case was her engaging with HOA leadership about a pending lawsuit in which she was the plaintiff representing herself, and the HOA was on the other side of it, and there was a lawyer. And Judge Peterson was engaging with them during the meeting, saying, if you hold a special election, I'll dismiss my case. If you do this, I'll dismiss my case. And so she was ultimately charged with a 1.1 violation, a Rule 1.1 violation that related to her violation of a state bar rule. And it was attempting to negotiate with somebody that she knew was represented, right? We obviously don't have that here. But she was also charged with there were additional charges related to Judge Peterson, and they are going to come to me, related to that activity. And this is the ground for discipline that was proven in that case. And the court did an extensive analysis there. And again, that piece of the Peterson case is very similar to this. It was that act that was, as a judge, outside of her judicial capacity, and the court found that it warranted discipline. And so I would ask the hearing panel to consider that decision when they're working through when you're working through the uncle phone call issue. All right. Switching gears to the 24 set of formal charges, and complaint number 22102, and that is the complaint involving Miss Alexander. Respondent spent, I think it was at least 30 minutes of closing argument on this one complaint. I'm going to go over each of the counts for the panel. There are 5 of them. Obviously, it goes without saying, this complaint is going to involve a whole lot of analysis and consideration of witness credibility. I know the panel knows that, but in order to make a determination about any of these counts, that is what the panel is going to have to do. And so count 1 is 1.2A, the failure to act in a manner that promotes the public confidence in the independence, integrity, and impartiality of the judiciary. The way that it was charged in this case is by listing off multiple facts to support that violation, multiple facts which are connected with an and at the very end. And so those facts are calling respondent a litigant in a pending case on her personal cell phone and speaking with respondent about her case, offering to handle and later actually handling the scheduling of respondent's case differently than other cases, canceling the 30-day hearing without notice or explanation to the opposing party, and failing to disclose the conversation with the respondent despite petitioner's attorney inquiring about why the initial hearing was canceled. And so a few things that I would ask the panel to consider. I will not stand before you and suggest that Ms. Alexander's credibility was not attacked or is not an issue that the panel has to seriously discuss. I own that, but that is the same for Judge Williams, right? Her credibility is an issue that the panel has to seriously discuss and weigh. And so what we have is the evidence related to, and I'm going to skip to the next slide right here, the evidence related to that phone call. One thing that I would ask the panel to think about is the fact that there has been a whole bunch made of this complaint related to Brandy Alexander. It makes up 5 counts of the many that are before the panel. None of it would have happened but for that phone call from Judge Williams to Miss Alexander. None of it. This snowball in disaster is the result of her picking up the phone and making that phone call. Now, Miss Alexander testified that when Judge Williams called, there was not any confusion about the fact that it was not a guardian ad litem case, and that it was a case in which she was a personal litigant. And if you recall, Ms. Franklin testified, her lawyer, that made the phone call to Judge Williams' chambers. She testified that she was the one that made the call. She testified that she spoke to Janelle Bowles. I understand Ms. Bowles said, I didn't take that call. Ms. Franklin testified that she spoke to Janelle Bowles and that she was expecting a phone call back. Never got one. But Ms. Alexander's testimony, not only at this hearing, but I would ask you to also review the transcript of her testimony before the investigative panel, because they did have her come in order to hear from her and Miss Aaron. Judge Williams started all of this, and if the panel were to accept her version as true, which is at the time I called, I didn't know that it was a case in which she was a litigant herself, the call should have ended right then. Right, at the very beginning, it should have ended then, right? There was no need for the call to progress beyond or go outside of the fact that, oh, you're a personal litigant. This is not one of your guardian cases. Let's not have this conversation. But it didn't. I would ask the panel to consider also, I know each of you have probably heard or know about witness interviewing and how investigators and other people are trained and taught to look out for contextual clues or, again, context, because it's important. But one of the things that I often noted as a sex crimes prosecutor when I was reviewing children's forensic interviews, just going through them to make a charging decision or preparing for trial, and you see it a lot with children, they oftentimes will add context and detail that is not necessarily relevant to the abuse itself. And it's context and detail, like the kind of detail that would be difficult to fabricate and just wouldn't make a whole lot of sense to fabricate, right? It's detail surrounding the abuse itself. And so I would ask the panel to consider the detail with which Miss Alexander recalled that phone call. And to a point that was raised during respondents' closing argument, Miss Alexander testified that for whatever reason, she felt like she was going to need a witness. Well, she did need a witness, because look at us. I mean, they completely went after her and dug into her about things that are very much collateral to this case in an attempt to attack her credibility. That's their MO, and that's fine. Let's attack the credibility and the integrity of witnesses, of the investigative panel, of the director, right? That's a big part of the defense. But again, Miss Alexander, with this phone call and the detail that she was able to give regarding the phone call, including, I needed a witness, and I think specifically she mentioned having a white female as a witness. So I flipped it on speakerphone. Something in her said, somebody else is going to have to hear this because I'm not going to be believed. And that's what she testified to. She also testified, in fact, to the fact that she never wanted to bring this to the JQC. She did not want to file a motion to recuse, but eventually it got to the point where she felt like she did not have a choice. But Dawn Smith took that witness stand and took an oath and very clearly told you what stuck out to her from that phone call. And it was the mention of them being sorority sisters more than once. And I guess in closing, there was an attempt, or respondent's attempt, or Mr. Banks' attempt to explain, well, if it did happen, this is probably why it happened. No. Judge Williams very clearly denied that that was said. She always has denied mentioning that piece of it. She denied it when she came into the meeting in May of 2022. She denied it here in this hearing. And so the panel is going to have to weigh that. We've got Judge Williams saying, no, I didn't say it, and Ms. Bowles saying, no, I didn't hear her say it. And we've got Ms. Alexander and Ms. Smith saying that it was said, and it was said multiple times. Why would that be the piece, right? Why would that be the piece? That is the piece that Judge Williams would not want to admit, because that is the piece that truly conveys or gets at, I got you. I got your back, right? And all of that was denied. That is the piece, and I'm sure the panel saw. I don't purport to understand this, but because I am not a member of an African-American sorority, but that is the piece. If you notice, with every single witness who there was a certain amount of it that they were okay to talk about, but it always got into a place where there was reluctance to speak on it. Like there was, discussion about, certain things are not discussed. There was, Judge Williams said, when I asked her what on the shield meant, she referenced, it's like saying something's like on a bond of oath, I want to say, which makes sense in this context. But again, I would ask the panel to consider the witness demeanor anytime it got into that space. My questioning about the sorority, there was a reluctance. There is some part of that is not to be discussed publicly, that people don't want to talk about publicly, but that piece of it is what gives, this is okay. It's going to be fine with me presiding over your case, because if you recall, this whole phone call was about a senior judge, right? Like, this is what starts it. And so Judge Williams talks about it, and it makes sense. Judge Williams explains, no, we can't have a senior judge come. And there was a whole lot of talk about that during the trial. We can't have a senior judge come. I'm going to be the one to hear it. And that additional piece, the reference to them being sorority sisters, this relationship that we have, I've got you. And so something that I would ask the panel as well to consider is any lawyer coming away from that conversation, we know the conversation happened between Judge Williams and Miss Alexander, any lawyer coming away from that, even if they had concerns like, hey, this is a dad-friendly judge, I'm a little bit concerned about it, not my favorite judge for this case to be in front of, you'd come away from that phone call and be like, this is going to go well for me, based on what was said. And so the idea that she did not want to file a JQC complaint or a motion to recuse her at that point, who would have wanted to after that phone call and what was said? And I'm going to pull you from the JO track and I'm going to handle it. That's the other piece of it. And we've heard a whole lot of this suggestion that she didn't get special treatment or that's not different treatment than other people get, but it is. You have a copy of the rules for JOs, and that initial hearing was supposed to happen in front of a JO. We've heard testimony, well, I did that with other cases, so Miss Alexander did not get preferential or special treatment because I do it with these sets of people, celebrities, employees of the county, in a transgender case. That's not how that process should work. There are rules in place about that process, and that say a JO handles those that first hearing, the first status hearing? Why isn't, if that's the case, if it's celebrities, county employees, transgender, or anything else I deem sensitive gets to come to the judge, why isn't that in the rule? That's not a rule. I mean, that's something that Judge Williams wanted to do on her own. I'm not suggesting that she didn't have the legal authority to do it, but those people are getting a benefit that other people do not get. I'm pretty sure if you polled every litigant in one of those cases, they would say, I don't want to be on that big mass calendar that takes hours and there's tons of people logged on here in my business and I'm having to wait around. Of course I want to be on the judge track from jump and have the shorter calendars and not on the calendars with everybody hearing my business. Judges all the time hear cases in which lawyers that they know are parties to the case, right? They're not acting as a lawyer. It's a personal case, especially judges in smaller rural jurisdictions where everybody knows everybody, right? That happens. And I am certain, maybe some do, but not all. I am certain that judges in those jurisdictions don't say, oh, this lawyer, it's their personal case. I'm going to handle it differently so I can shield them. No, they should be handled the same way as everybody else's. And so that's what I'd ask you to consider about that issue. We've talked about count 1, count 2. Permitted a relationship to influence her judicial conduct and judgment. I've already walked through how the relationship influenced her, but for her relationship with Miss Alexander and that comfort level, I don't think there would have been the phone call in the first place. And that phone call is how we got here. The ex parte rule, the 2.9A, that violation, so when the panel is looking through that rule in the code 2.9A, there is an exception for scheduling and administrative purposes, but that exception says where circumstances require, right? So when I go and I train judges on ex parte communications, I tell them, do not rely on this exception or allow this exception to become the norm because it shouldn't be the norm. This exception should only be applicable and should only come up when the circumstances of the case require you to have those communications, right? And then again, the judge is supposed to determine that nobody received a procedural advantage, and then they are supposed to make prompt provision to notify the other parties and to give those parties an opportunity to respond. Judge Williams has suggested that she did notify her staff. That's what her staff says. The notification didn't happen. So that's where we are. But again, I don't think this is a circumstance. I don't believe that we get into the details of that exception, because in order to get to that exception, the panel has to make the determination that circumstances required it. And I would submit that they did not in this circumstance. The count related, this is count 4, 1.2A. That is the count that relates to the statement that Judge Williams allegedly made to Ms. Aaron that she was going to show respondent personal and reference giving custody of respondent's child to the father prior to the conclusion of the hearings in the respondent's case. So both Ms. Aaron and Ms. Alexander came before the investigative panel to testify for a reason. That is not incredibly common to have witnesses come in. And so what the investigative panel does on that level, and again, I would note that the panel's determination, the investigative panel, their role and their job is to make a determination about whether there is reasonable cause to believe the code has been violated. That standard, if you think about it kind of like the grand jury standard, where probable cause is required, and then at the trial in the criminal context, beyond a reasonable doubt is the burden of proof. The investigative panel's burden and what needs to be shown at that point is different than the burden here before the hearing panel. And both of those witnesses came before the hearing panel, and they made a credibility call. And Judge Williams came before the panel too. And again, they made a credibility call when they directed the director at that time to file formal charges. And what I will say is, again, all of this turns on credibility. And I think at this point, with the burden of proof, we have Judge Williams saying she didn't say it, Ms. Aaron saying she didn't say it, Ms. Alexander very clearly, both before the investigative panel and in her testimony here. In fact, that's what led her to make the statement that was put up in big red about burning the judge's house down if she took my child. That's what enraged her to that point, to make that statement, was hearing when Ms. Aaron said to her, she said, I'm going to show her personal when I take her kid. I understand that we just have Ms. Alexander making that statement. I would ask the panel to consider Ms. Aaron's statement to the investigative panel and Ms. Alexander's statement to the investigative panel, and the multiple similarities that exist between those two statements, but for adamance about that statement, which would be the most damning. It would be the most concerning, obviously, if a judge is threatening to make a decision in a case based on being mad for somebody for filing a motion to recuse. A few things about Judge Williams' testimony on this complaint. When she came before the investigative panel in May of 2022, she was asked multiple times, maybe inartfully by me, but eventually Mr. Boring got to it, about whether or not she had spoken to another lawyer or another member of the state bar.
I may object. That's not a
Is it, well, what's your response? I thought I understood you to say it was part of the transcript.
It is part of the
Guys
transcript.
admitted as an exhibit,
Yes,
right?
so it is in the record.
Okay, then I overruled the objection if it was in that transcript you admitted.
Yeah.
I think there's a transcript of Brandy Alexander's and the video on Aaron's. I don't think there's a transcript of Judge Williams' testimony and evidence.
So I
I
believe.
haven't seen it.
It's not there.
Well, let's double check. Obviously, if it's part of the record, then it's fair game. If it wasn't admitted as evidence, then I agree with Mr. Banks's objection.
And perhaps I am misremembering, but there was testimony by Judge Williams about those specific questions. And Judge Williams is the one who said, I think Mr. Boring eventually got to it and asked me, hey, another lawyer outside of your staff that is a member of the State Bar of Georgia. That was in her testimony. So what I'm talking about is in that transcript, but she also testified to
You're
it.
talking about live and in,
Correct. Here
Right.
during the course of this
Okay.
proceeding.
okay.
And she said during the course of this proceeding, I do not recall talking to anybody else. I don't remember speaking to another lawyer. That was what she said, and she agreed that is what she said to the investigative panel in May of 2022. That is in the transcript of her testimony from this proceeding.
Okay.
So we fast forward, though, to here at this proceeding in 2025. She testifies, yes, I spoke to Ms. Aaron. And her reason, when I asked her, you said you did not recall at the meeting in May of 2022, she said that she did not remember having that phone conversation. And the reason that she did not remember was because she had worked late and she had spoken to her after work, and in fact, she fell asleep during this phone conversation. And so again, her explanation was she just didn't remember having that conversation. Again, I would ask the panel to consider how clear her memory is on other things that may be more helpful to her, and how she often conveniently does not remember or does not recall other things. Because at the time she came before the panel, she did not know that we had spoken to Ms. Aaron, or she did not know exactly what we knew about that phone conversation. So again, her testimony here, oh yes, I did have that conversation. She reminded me when she filed a motion to recuse. And I fell asleep during the conversation, just didn't stick out to me. She characterized Ms. Aaron as an associate, but then said The way in which they got on the phone was Miss Aaron left a message for her indicating it was personal and just to call her. And then they talked about her recently having a baby, her weight, a dispute with Miss Aaron and one of her sorority sisters. And that's what prompted Judge Williams to mention this issue. One of the things that Judge Williams did deny about that phone conversation here in her testimony was that she did not indicate or say to Miss Aaron how she was going to rule on that motion to recuse. And she also denied reference to the fact that she could not recuse from the case because she would have to later stand for re-election and it could impact her in a future election. It would make it look as if she had done something wrong. I specifically asked Judge Williams about those things, and it was either no, I did not say that, or no, I don't recall saying that. Those are things that Ms. Aaron, both before the investigative panel and before the hearing panel, very clearly admitted and with some detail. When I asked Judge Williams about whether or not she said, I cannot recuse or I cannot just, get off the case because it could impact me in a future election. Instead, she wanted to talk about a circumstance where she had voluntarily recused because somebody involved in the case was, I believe, a former partner or worked at her previous law firm, which is obviously completely different because, as we know, Judge Williams testified that she was upset by the allegations contained in the motion to recuse. The panel has the motion to recuse, and it has Judge Williams' orders that correspond to that motion to recuse. The first order she issued was an order denying the motion to recuse, and then the second order she issued was an order voluntarily recusing herself from the case at issue. And so count number 6 in the 24 formal charges is the violation of Rule 2.5A, failed to perform judicial duties competently and without bias or prejudice in violation of that rule by issuing the orders that she issued. And so Mr. Banks correctly noted that there is commentary in the Code of Judicial Conduct about weddings, but as you will see, Rule 2.5A discusses both the performance of judicial duties competently as well as administrative duties competently. The focus here is on judicial duties competently because in issuing those those orders on the recusal motion, Judge Williams was upset enough that she felt like she needed to refute the allegations contained in the motion to recuse and the accompanying affidavit, which I don't know for how many years this law has existed in the state of Georgia, but it's all over our jurisprudence, both with the Court of Appeals and Supreme Court, that when a judge opposes or offers evidence in response to a motion to recuse, they make themselves an adversary of the person seeking their recusal. You are not supposed to do it. And so that is the basis of that charge. And so, again, I understand, I believe Judge Williams said she didn't know about that until I said it at trial, or maybe I think that was what her testimony was, which is a little bit concerning. I think Superior Court judges are taught about that at new judge orientation. So that is the basis for count 6. On ex parte communications, again, I'm citing to Peterson, a very recent and the most similar and relevant case for the hearing panel to consider when it's considering what discipline is appropriate in this case, as well as the violations. Peterson at footnote 12 reminds us, and I think this has kind of been lost in all of this, that engaging in or allowing ex parte communications presents to the public an image of a judge who covertly interacts with the party in order to unfairly advance that party's interest and jeopardizes the appearance of the independence, integrity, and impartiality of the judiciary. And so There has been a lot of suggestion to the panel that they did not talk about the merits of her case, that there was not discussion about the substance, and that she did not get a strategic advantage. That is not required in the rule about ex parte communications. What needs to be kept in mind about ex parte communications is engaging in it or allowing in it creates a picture for the public that is not favorable for the judiciary, right? It's not about, I think, the impact of ex parte communications and did it negatively impact the person on the other side. I think that piece is certainly relevant when we're talking about ex parte communications, but relevant in an aggravating or mitigating way. It's not relevant to whether or not there was an ex parte communication. And again, ex parte communications are prohibited for this reason, in order to avoid situations, messes like what this became, right? But for that phone call, we would not be discussing this. She set this in motion with that phone call. So the grounds for discipline relevant to those counts in the complaint related to Ms. Alexander. Willful misconduct in office, again, there's a bad faith requirement there. If the panel does not find bad faith, conduct prejudicial to the administration of justice, which brings the judicial office into disrepute. For that ground for discipline, the actions are inappropriate actions, but actions taken in good faith by the judge. So that requires, I think, the panel to explore whether or not the judge was acting in good faith when they did the things, which I think is going to be very interesting in this case. So something else, and I think this this relates to the bad faith, good faith piece here, because it's turned into, and it's been portrayed as, the phone call happened, I didn't say all the things they're saying I said. I told my staff to notify the parties. They didn't do it. And that was on October 18th of 2021. We then fast forward to the hearing in December of 2021, for which you do have a transcript. And in that hearing, we discussed it during Judge Williams' testimony at some detail. The parties are there. And there is discussion about the petitioner, so the opposing party's attorney mentions during that hearing that she had inquired of the judge's chambers about why the October 28th, 21 status hearing was canceled. She got no response. And during that hearing, this is the one where Judge Williams does say, and she's the one to introduce the fact, hey, Miss Alexander is a guardian in cases before me, want to put that out there, and then the whole conversation about recusal ensues. Here's what I think needs to be considered about the panel, or by the panel. Judge Williams testified here before you, and it was during her first day of testimony, that at the time she presided over that hearing in December of 2021, she was under the impression that her staff had communicated to the parties what she said about, her testimony was, I told them to tell them that I talked to Miss Alexander, she's a guardian before me, and then the case is going to be moved from the JO track to in front of me. That was what was supposed to have been communicated, right? And then her staff was also to handle the rescheduling of the October hearing, for which the parties didn't get notice. But Judge Williams testified that when she takes the bench in December of 2021, she was under the impression, I thought my staff communicated or had that communication with the parties such that they would have known that I talked to Miss Alexander and that she was a guardian before me, right? If you look at that transcript and specifically what the petitioner's attorney says, the petitioner's attorney at that hearing when Judge Williams says, I just want to let you guys know that Miss Alexander is a guardian before me, the petitioner's attorney says, this is the first time I'm hearing about this. The petitioner's attorney also has said, I asked your chambers why they canceled that October hearing, why it was moved, and her words were, why it was diverted from the normal course, and I didn't get a response. Judge Williams testifies here before you all that she didn't deem it necessary at that point. She now knows, the petitioner's attorney knows nothing. It's very obvious to anybody that nothing had been disclosed. And so when I asked Judge Williams why at that point, you've already disclosed that Miss Alexander is a guardian with cases appearing before you, you've gone through this whole exercise to prove that, multiple judges would have to recuse if it were the case that just because she's a guardian before you, you have to recuse. You've gone through all of that. Why wouldn't you have then told them, hey, the reason the case got moved, I hear you just asked me, I asked your chambers why it got moved and I didn't get a response. Hey, by the way, since we're talking about Miss Alexander, and you've also told me today's the first time you're hearing that she's a guardian with cases before me, I spoke to her, I had a phone call with her. And this is what we said on the phone call. Instead, she, during this trial, said, well, no, up until that point, I still thought that they had that email communication and they knew that I talked to Miss Alexander. It doesn't make any sense. It just does not make any sense. Everything at that hearing that came from that petitioner's attorney made very clear that she did not know anything about that phone call. She did not know anything about Miss Alexander being a guardian and having cases before Judge Williams. She did not know anything about it being moved from that October date. And when Judge Williams had the opportunity to put it out there, I had this phone call with her. She didn't do it, and she didn't do it because she knew it was an ex parte communication and it was improper. That's why she didn't do it. It's not because, I thought maybe my staff had told one part of this or I was under the impression. No, reasonable judges in that position would have disclosed it like that. And so I would implore the hearing panel to read back through that transcript and specifically the pieces that I've mentioned regarding the petitioner's lawyer. And again, I think that piece of it obviously relates to the judge's credibility, but those considerations relate to this bad faith, good faith analysis that the hearing panel has got to conduct when it is determining which grounds for discipline are warranted if you determine a code violation and that discipline is in fact warranted. All right. Shifting back to the 24 set of formal charges for the failures to promptly issue orders. We put a chart in here because there are a few things that I think are important. We talked about a whole lot of cases. There are 15 of them. Many of them span multiple years. And there was a lot of time spent during the course of the proceeding talking about Ms. Bowles, her job performance, how she got behind, and that's all well and good. But what I think is important and what these charts show, and I'm going to provide the closing to the panel so you can have it for review, is that these hearings, there were some of them that occurred before Ms. Bowles got there, right? So she wouldn't have been the one responsible for drafting the orders according to her testimony. And then we've got another chart as well. And I would ask you to consider that Ms. Bowles left in June of 23 and Ms. Green started in July of 23. And so Ms. Green picks up there after Ms. Bowles and continues on. And we'll talk about Ms. Green here in a little bit. But again, I think it's important for the panel to know hearings on some of those cases happened before Ms. Bowles even started. So the Green versus Green case, we have 2 counts related to that case, count 7 and count 8. There's a 1.1 violation and a 2.2 violation. I'd note that today in the admissions today say she admits count 7. I don't think that it's been admitted based on the testimony and everything that's gone on during the hearing, so that's why I have no there. I was under the impression that she did not admit that count. Regardless, the dates I have up there, again, we've talked about all these cases, and we've talked about, like, okay, there's 30 months that passed between the final hearing and the entry of the final order. One thing that I want the panel to know is that in drafting these charges, thought was put into where does the timer start, right? And so we're not penalizing Judge Williams for a case that was pending and languished before she took it over and conducted the final hearing, right? So there are a few of these cases. There's one where another judge conducted the final hearing, and then Judge Williams inherited the case after that. But again, I want the panel to understand that the time for the delay, it began at, or we started counting at, the time that Judge Williams presided over the final hearing. She was not penalized for delays in the cases that happened before that. I think that that time is relevant for judges to consider when they are scheduling their matters and trying to get things closed, because of course a judge, would prioritize something that had a petition that had been filed in 2017 over one that had a petition filed in 2022, because the case as a whole has been pending longer. So something else I would note with all these dates, and I'm not going to read them into the record, I'm going to give you all these charts, but as you recall, on many of these delayed order cases, we had to notice her twice. And so, again, this just goes back to, I appreciate that she had to go through multiple staff attorneys to find the right one. That happens sometimes. I appreciate that Ms. Green came in and was like, whatever has been done previously, that doesn't work for me. And so I'm going to come up with a system to make sure this operation runs more smoothly. And it does appear that after Ms. Green started, not that there weren't any delays, but it does appear that things picked up and began moving more quickly. But again, we had to notice Judge Williams on some of these cases twice. And so the idea, she testified that Mr. Hyde asked her what she thought the appropriate sanction would be for just the delayed rulings. He was trying to get at what she thought was appropriate. She testified that she had heard that the investigative panel sometimes would do private admonitions on failures to rule or a reprimand, depending on the case. And so I would say, again, things that are resolved at the investigative panel are not public, but having to send 2 different notices to remind after a judge has already said, got your first notice, I'm going to do some of these, I'll have them done within a week. They assign themselves a deadline. I'll have them done within this week. Not only is it not done then, not all of them, months pass, and they're still not done. And so the investigative panel has to go back and say, where are these orders? And so this is more than a new judge starting off with a large caseload and finding their footing. I'm not suggesting that what she inherited was not a significant caseload. It was. But this is a judge who came in, and by the time that we're noticing her, July 20th of 2023, she took the bench in January of 2021. And again, so we're having to go back months later and send additional notice on some of these cases because she has not done it. And Judge Williams' situation with the volume of delayed rulings and not just the volume, but the amount of time that passed between the final hearing and the rulings, coupled with the circumstances where motions were submitted and ignored or didn't have hearings, never issued a decision or an order, that is a circumstance that is abnormal and an outlier and would not, in my experience since I've been here, would not result in any kind of private discipline at the investigative panel level when we are having to go back and remind a judge, and we have this many cases with delays and these significant of delays. So this is Miller versus Miller. It's the next case in the 24 set of charges. The hearing panel has many of these documents related to the cases again, so I'm not going to read through them, but the documents that I think are important related to the delayed ruling cases are the emails from the attorneys to Judge Williams' chambers. And if you look at those emails, oftentimes it's not just one member of her chambers that's copied on those emails. So the idea that Ms. Bowles, single-handedly dropped the ball on, the majority of these cases is just inaccurate. You all heard a whole lot of testimony from multiple of her staff attorneys, but specifically Ms. Bush and Ms. Bowles about the fact that both of them, regardless of how they were doing it, had some system or checklist in place that the judge was aware of and the judge could see. There was a way of tracking these things, and surely as the judge that presided over these final hearings, again, ultimately at the end of the day, this is up to the judge to ensure that it is done. Again, in this one, the investigative panel sent the notice. She got this one done pretty quickly after she got the notice, and it should have been because there were 26 months between the final hearing and the entry of a final order. And as you'll see in here, the proposed orders on Miller versus Miller were initially sent to Ms. Bush, and then they were resubmitted to Ms. Bowles. So we have two different staff attorneys being involved in the Miller versus Miller matter. Here's an example of one of those emails where the attorneys are reaching out. But specifically in this one for Mr. Chambers, this is in February of 2022, he indicates that they had a status hearing before Judge Williams in January, and it was our understanding from that conference that the orders had been prepared but not filed, and Judge Williams indicated she would get them filed. Could you please provide an update at your convenience? And he sent this email, and that's Judge Williams telling him, right, that they were prepared and needed to be filed. He sent this email February 4th of 2022. An order was not entered until August 3rd of 2023. And so this is after the judge saying that the orders had been prepared and just needed to be filed. And so pieces like that, again, I think they're important as the panel considers appropriate discipline in this case. Klein versus Klein, we had a 1.1 violation that related to the motion for immediate hearing and motion for immediate entry of final order, which was filed as a result of not getting a final order in the first place. That motion was not heard or decided. We noticed the judge in July of 2023. She gets the final order out, and that relates to count 2.2 on September 29th of 23. We've got a 14-month delay there. You can see that also in this one, the proposed orders were resubmitted to Brittany Green on July 19th of 23, and Judge Williams issued the order September of 23. Here's another email example. Again, you all have these, but this is where the attorney in the case is emailing courtesy copies of filed motions. So again, a suggestion that, they were e-filed and the chambers did not always get them. This is a circumstance where the attorney emailed the courtesy copies as well. And you also see here, please be aware that since filing yesterday, Mr. Klein's contempt is escalating. Those are the pieces of this that I certainly don't want to get lost, the impact on the people that were waiting for months and months and months, and some of them years on these orders. Thompson versus Hawk, that's just a 2.2 violation. This is another one where we had to send more than one notice, and even after that second notice, she took a number of days to get that final order out, 17 months between final hearing and entry of final order. This is Ritter versus Lopez. There's a 1.1 violation and a 2.2 violation. The motion in this one was, again, a motion that was filed as the result of the judge not having entered a final order. In this one, she entered the order in January. Shortly after, we had to send the second notice. I would also ask the panel whether or not that is something that the investigative panel should be having to spend its time doing, is keeping track of these cases and sending multiple notices to sitting judges to please do their work.
How do you transmit those to the different judges? the IP notice to judge and second IP notice to judge, do you email it, do you deliver it, do you mail it? How does that work?
If they have an attorney that is accepting service on their
Okay.
behalf, which was the case with Judge Williams, we send it to the attorney. If
Okay.
they don't, we email it and we put it in the mail.
Okay.
Diffley versus Moore. In this circumstance, the proposed orders, you'll see this in your case materials, were submitted first to Ms. Bush, then to Ms. Bowles. There were 9 more emails sent requesting a status. We had to notice Judge Williams twice on this one. The delay here was significant. It was 30 months between final hearing and final order. Colon versus Storch, this is one where another judge was the one that presided over the final hearing. It was a divorce case. The case was sent back from the appellate court. That judge entered another final order on December 14th of 2020. The litigant, Mr. Storch, he's the one that testified. He filed another motion for new trial, and then Judge Williams inherited the case after that motion for new trial was filed. She presided over the motions hearing on June 15th of 21. After waiting, he filed the motion to enter judgment, and she entered that order 23 months between the hearing and the order. And then the 2.2 violation, again, it was 23 months between the hearing and the order. And Judge Williams has admitted both of those, but we have almost 2 years delay in that circumstance. I put this up here. It was from Mr. Storch's testimony, talking about the impact to him, the delay, and what it meant for him. He was without his property, funds, my personal belongings, my business, my income. I was borderline homeless and hungry. I had health conditions I couldn't address, and it was pretty serious at my age. Again, the impact on the people awaiting these orders is something to be seriously considered. The delays related to the formal charges, the 25 charges, again, here's a chart that relates to the 25 set of charges. So I think it's important, and this one has Ms. Green listed on it. Just for reference, you can see when Ms. Green started, when these hearings occurred, and then you can see when the final orders were entered. And so if you see like the blue line, the one at the top, Cerny v. Waddell, that says February 15th, that first date, that's going to correspond with the year 2022. That's where that line begins in the graph. Ms. Stone made these. She's better with technology than me. It took me a minute to figure it out. June 27th is that second date. That's when the case ended, and then that falls in the 24 category if you look above it for the years. So that's how you know the years. But again, just to see, Ms. Bowles was certainly there during delays on many of these cases. But Ms. Green, when she started, she was, and you'll see with the emails, she was on many of the emails, and there were some orders that were delayed after her time, beginning with Judge Williams. This is Cerny v. Waddell. That was 28 months between final hearing and entry of final order. And in this one, the parties had submitted their proposed orders in March of 22 to Ms. Bowles, and then sent several subsequent emails to Chambers. In McFarland versus...
Ms. Veal,
Yeah.
I'm going to be the time cop. You're also significantly over your
Okay,
hour.
I'll hurry.
I've tried to give you as much time as Mr. Banks had, but if
Okay.
you could start sort of landing the plane, that would
Yes,
be great.
sir.
Yeah, we still have questions.
Yes, sir. All right, email, you all have that. I won't read it for you. Here's another email. I would ask that you all read it during your deliberations over this case. And this one, multiple emails following up. And those emails, by the way, are to Ms. Green. Snare versus snare, the dates are on there. We had to notice on map versus map. This is another one, 21 months, another one, 14 months. There's an email with that one. And center versus center, that's the one Ms. Center testified. That was 29 months between final hearing and entry of final order. This is a piece of the transcript from her testimony. I would ask that that be considered. Again, the impact on her was pretty apparent. So one of the things that the hearing panel wanted us to talk about was prior disciplinary cases, which, and this is my word, which may be relevant to this one as you all sift through the appropriate disciplinary action. And so one that was not touched on earlier is In re Anderson, and that's 304 Georgia 165. It was a 2018 case, and in Anderson, that was also a discipline by consent. It was an isolated instance of an ex parte communication by a chief magistrate judge in Tatnall County who was a non-lawyer. He was upset about a woman's car being repossessed, and he was calling the owner, telling the owner to give her the car back, or she's going to file suit in my court and it's not going to go well for you. And the woman did end up filing suit in his court. And so that was a public reprimand. I will note in the Anderson matter, factors in mitigation that were considered by the Commission and the Supreme Court were Judge Anderson's candor during the meeting with the investigative or with the commissioners at that point, because, well, it was 2018, so I guess it would have been, regardless, candor during meeting with the JQC was listed as a mitigating factor. They also said that his action was not undertaken in bad faith or with malice, but rather in an attempt to get the matter resolved for the woman. And that was a public reprimand for Judge Anderson. And again, that was an isolated incident that related to an ex parte communication. We have talked about Judge Hayes, but something I want to emphasize with the Hayes matter, and he's the one that shoved the inmate. Judge Hayes came into the investigative panel meeting and admitted what he did, and that's noted in the public opinion. He accepted full responsibility for this isolated incident. Again, it was an isolated incident, and came in and accepted responsibility. That was a 30-day suspension, and which was unpaid, and a public reprimand, and he was a chief magistrate, non-lawyer judge. I would also note that there is obviously not an excuse for getting off the bench and shoving an inmate, but that happened after the inmate was essentially berating and cussing the judge out, and continued to do so as he was let out of the courtroom. Again, I'm not excusing it. It's incredibly serious, but those are the facts in Hayes. In Gundy, which was mentioned during respondents' closing, again, that was a discipline by consent agreement to a 90-day suspension without pay, as well as a public reprimand.
Which was really a non-suspension suspension because she got paid for the 90 days, didn't she?
She actually did not.
Okay, good.
She was an associate municipal court judge. She is a lawyer. In that case, the violations were habitual tardiness, excessively absent, and then there were 6 individuals who remained in custody longer than they should have because Judge Gundy did not hear their cases in a timely manner. And again, that was a 90-day suspension without pay and a public reprimand. And in that circumstance, the Supreme Court noted that that sanction was one of the most serious that it had imposed, short of removal. The respondent talked about inquiry concerning Judge Norris. One thing I want to note about Norris is that Norris was an isolated incident. There are a lot of mitigating factors laid out in the Norris case that were presented by him. The comparison between the Judge Norris situation and the Molly Dennis situation, there are certainly some similarities. The Norris matter was incredibly serious, as is the Dennis situation. But again, Norris was a one-time incident. That's the only issue that was raised in the Norris case. That was the only violation was related to that one incident.
He had several weeks between this offending post that somebody had the temerity to put on the social media.
He did.
And then coming in, so he had time for the voice of reason to calm him down, colleagues, counselors, spouses, whatever. The respondent made a call right then, she could have held her in contempt. I see it a little different, and I would have removed Norris. I
Sure.
was disqualified.
So Ms. McFadden was actually on the hearing panel for Norris, and she dissented as to sanction and recommended a censure, which obviously that would have been wonderful. But it was in that opinion that the Supreme Court said censure is not available for judges who do not
Which
hold
was the first
statewide.
time that's ever been uttered.
I think that was the first time, although
In Georgia.
I do think that it came up in the Judge Gundy matter in a sealed pleading that is still not public. But that is the first time in a public opinion that had been stated. And I would say, Mr. Hyde, to your point, Judge Norris did have days or weeks maybe to cool down from the social media post that made him so upset. But I would also submit that Judge Williams, I don't believe there's any testimony before the hearing panel that she was, I think it'd be different if she said, I lost my cool, I was really frustrated with this girl, and it was a bad response to my frustration with her. It didn't seem like there was any of that. I mean, in fact, if it was truly about her behavior, right, or what she was doing in the back, or her daddy issues that she talked about when she testified, why wouldn't you address the behavior at that time? Instead, we've gotten all the way to closing arguments. We're in the middle of closing arguments, and somebody said something that reminded her of what happened, right? And at that point is when she wants to teach her the lesson. It's not, at the time these things are going on. As I said earlier, there was a way to communicate the lesson or to speak to Ms. Dennis that is not what happened to her. And so the cases are obviously different in many ways. So interestingly, the Coomer case and the Peterson case were completely left out earlier. And as I've already explained, the Peterson case is very, very similar to this case. There were different sets of violations. Some of Judge Peterson's violations had to do with social media conduct that occurred prior to her taking the bench. She also had an allegation related to ex parte communications. And that allegation in Peterson related to Judge Peterson's clerk reaching out to a potential individual who may have wanted to file a caveat after the office researched her address because her notice got sent back and was not signed by her. So the clerk reaches out to the woman about whether or not she's going to file a caveat. She's allowed to file a caveat. The other side is not notified, and then a complaint ensues. Ultimately, Judge Peterson ruled the caveat was timely. She recused, and the case went to a Superior Court judge who reversed her decision. So that ex parte communication situation, there was harm to the other party because, again, they weren't told that this person had gotten additional time to file a caveat, and then Judge Peterson ruled that it was timely.
But Peterson's conduct in the courtroom at our hearing was completely different than Judge Williams, in my view. And Peterson made false statements. She was dismissive. Her conduct was different than Judge Williams, in my view.
So,
And we take that into consideration in making our recommendations, I think.
well, yes, you can, and that's what I argued in that case, but I'm also going to argue that in this case.
Okay.
I'm not saying that they are the same, but my view is that judges have an obligation to be forthright and to be truthful, any question, any issue that comes before you. And I think that there were certain things that Judge Peterson did that may have been more aggravating than some of the things that Judge Williams did. But I would also remind you that there was a point at which you got under Judge Williams' skin so badly that she raised her voice at you. And I know everybody up there noted it and saw it. I could tell by the reactions
I do that to a lot of people, but I don't remember it.
Okay.
I'll take your word for it.
But so what I'm going to ask is that the panel consider her conduct and her demeanor. I mean, it was to the point that we had to take a recess on that day of testimony, and it was the second time that she testified. So I'm not saying the behavior is the same, but I disagree with the characterization that it was completely different. I think there were a lot of things that Judge Williams answered or said that were not truthful, and she was not being forthright. And again, lack of candor, I think, is a major issue that the panel has to consider.
Can you specify which areas you believe she was not truthful?
Yes. So going back to the Brandy Reeves situation with the phone call, I'm sorry, I went the wrong way. I've got him here. So I've already gone through this, but again, it's what she said during the call to Brandy Reeves, specifically denying reference to them being sorority sisters. And again, Dawn Smith also said that Judge Williams said that she was going to have her back. I believe that was kind of related to, or that followed the statement about sorority. And I mentioned this earlier because, again, perhaps to the panel, I don't know, to me, there is a reason that piece of this is being denied. Obviously, my position is not that these two witnesses have come in here and fabricated the fact that was said, but that being said, again, I think that clearly communicates you don't want to admit that you are referencing a special relationship that you and a party that appears before you has. Like, a judge would never want to admit to something like that, to referencing that special relationship. And so something else is Miss Aaron's statements, and you heard it through Miss Alexander too, but Miss Alexander is not the one that Judge Williams said it to, but specifically about the motion to recuse and Judge Williams talking to her about how she was going to handle the motion to recuse, and the fact that she did not want to recuse because it could impact her in a future election. I specifically asked her about that, and it was a no about that. And so that's another issue. Something else is the issue that I brought up earlier about, and this just may be, I viewed it as, again, a lack of candor, but it does not make any sense that when you are in court in that December of 2021 hearing, that the petitioner's attorney has said these things to you, and then at that point you do not disclose that you had that phone conversation. And this is not even 2 months after the conversation with Miss Alexander. And Judge Williams testified to the panel that that was because she thought that her staff had disclosed the conversation. And again, it does not make any sense in the context. And so I would ask the panel to, again, review that transcript and to seriously consider whether or not Judge Williams was being forthright in her answers about that issue. So the phone call regarding her uncle's case with Madison Alexander, Judge Williams, and I've already walked through this, if you look back at her testimony when I asked her specifically about asking for the extension or saying if the case came before her, she would dismiss it, I asked that that's where the panel considered, that's when she doesn't know or she doesn't recall.
You said Madison Alexander, but I think you meant Bonnie Stinson,
I'm
right?
sorry,
Madison
I'm sorry.
Alexander,
I have
think, was from the Molly Dennis.
That's right. I'm sorry. I have
case.
MA in here, and that's what threw me
But
off.
we're talking about Bonnie Stinson.
That is Bonnie Stinson.
Got
I'm
it.
sorry. That is Bonnie Stinson. And so those two, I don't know and I don't recall. Again, when you compare that to the fact that Judge Williams can remember things from several years prior very, very clearly, I think that should cause the panel concern. She then heard Ms. Stinson testify and then got back up and tried to clean it up and explain it. And again, I would ask the panel to very seriously consider and scrutinize the things that she said after she had the benefit of hearing what everybody else said and had time to think through how you might clean it up on the back end. So those were the things that stuck out to me with her testimony that I noted. So aggravating factors, that is another thing the panel specifically asked for us to cover. Again, the seriousness of the transgressions. We have multiple violations that are very serious in this circumstance, a pattern of improper activity. That existed in Peterson, and it also exists here. And again, she has continued to get JQC complaints despite the fact that she was under investigation by the JQC investigative panel. And I would also, I would regret not bringing this up if I didn't. And I know I'm over my time, but they started their closing argument with a picture of former Judge Rebecca Reeder up on the screen. You know, like other people, there were a bunch of pictures and cartoons up there today, but that really is representative of the defense in this case. Cartoonish, and let's blame everybody else, right? If she's truly accepting, I said it was in the opening.
If it was, you said closing. If you meant opening,
I meant
agree.
opening.
I think the first picture we saw was actually of Judge Williams, I think, in your closing.
So they removed her for the closing PowerPoint. But it was up for a significant amount of time in opening. We had other pictures today. And again, the cartoons, cartoonish, and let's blame everybody else and impugn the integrity of multiple other people involved in this process, including me, including two of my investigative panel members, including multiple witnesses. Everybody else is on trial. And there is language out there in multiple JQC opinions that says judges have a right to defend themselves. But it talks about, and I would ask the panel to consider what is acceptable, right? What is acceptable? Is it acceptable for a judge to come in and say, I admit, but then in argument and through the way that witnesses are questioned, attack and blame everybody else? Because that is what I've heard. I mean, going all the way from her furniture was taken and somehow that having anything to do with all of these violations. And I would ask, so since Judge Williams has become fully furnished, these violations of the code are what she has accomplished. That's what she has done since she's got all of her furniture. All these violations of the code that are before you. And I would ask, which of those violations of the code does Rebecca Reeder have to do with? None. Zero. And all this argument about the investigative panel and myself and what we didn't do and what we did wrong and we should have done this and we should have investigated this person and Judge Williams has wanted to work this out this entire time, I would ask you to consider whether her demeanor during the course of this proceeding, specifically when I was trying to ask her what she admitted to and what she didn't, is that consistent with a judge that is truly wanting to come in and accept responsibility for their actions? And it is true that in Judge Williams' case, as with other judges who are under JQC investigation and continue to over and over and over and over and over again get complaints, it is true that at some point the investigative panel views the situation as this is a removal situation. And there is no other sanction that can account for serious transgressions like this and the number of violations of the Code of Judicial Conduct that are present before the panel to consider. Judge Williams said that for the Molly Dennis situation, she thought a reprimand was sufficient. In relation to the failures to rule, a private admonition or a reprimand, I mean, are we just going to stack reprimands? And a suspension in this context is difficult for me, and it always has been, and that is because, and one of the questions was, can you impose an unpaid suspension, or can an unpaid suspension be imposed? So I think the hearing panel can recommend a sanction that it believes is a sanction that can be imposed by the Supreme Court. And in the Peterson case, she was removed, but there is a concurring opinion in that case written by Justice Peterson that was joined by Justice Boggs, where Justice Peterson says that his opinion is that the unpaid suspension is constitutional. Now, again, it was a concurring opinion by Justice Peterson and Justice Boggs joined, and that is in the Judge Peterson decision. And so I think if the hearing panel I'm not advocating for any kind of suspension, but if the hearing panel thought an unpaid suspension was appropriate, I think you can appropriately make that recommendation to the Supreme Court based on that concurring opinion. My issue with suspensions, less the unpaid, but even still, is that you're removing the judge, and yes, they don't get paid for that time, however long it's been. I think the longest one we've done is 90 days, and that was by agreement. But, you know, the taxpayer is still, they're paying somebody else to come in and fill in, assuming that that's what's done. And then the judge just goes back to work. And so, you know, I in situations like this one, especially where we have a jailing that was not lawful and a young adult set in a holding cell that they had never seen anything like it before and thought they were going to be carted off to jail, and that shaping her view, at least in part, of the system, or when we have a judge, again, who makes a phone call like the one she made after she's been constantly under investigation by the JQC. I do not see how a suspension accomplishes what needs to be accomplished in this circumstance. And I understand she's got a whole lot of public support, and that's great for her. Most judges do have a whole lot of people that support them. The reason I did not just agree to all of those letters of support coming into evidence was because I needed this panel to see that there were some people, there are people that are going to come here, and no matter what, for the ones that testified, I think, or at least two of them, it did not matter if the stuff in these charges was true, right? Molly's dad, he was having none of it. None of this was going to change his opinion at all, right? And so a judge could have been proven to do all of these things, and he's still going to vote for and support her. And I guess that's the reality of our system, right? A lot of times we have judges that are going to come before this hearing panel and they have people supporting them, and they're going to say they're great and they deserve to be on the bench, and I would vote for them again, but I needed the panel to see that, again, even if proven, it would not change their opinion. I think that's important. There were two witnesses that testified that they see judges do things all the time and don't report it to the JQC. And there's a reason those things aren't reported to the JQC. If they're the kind of lawyers that are fine with letting stuff like that go and harm to their clients occur, fine. But they are not going to be part of this process or engage in it. And again, I don't believe there's anything that Judge Williams could do to change their view. For the people that were harmed, they are the public too. The public is not just the people that support Judge Williams. This is an excerpt from Coomer, where they say that we do not expect judges to be perfect. They're human, but we can and do expect them to be honest. The judiciary has no place for dishonest persons, and that was in reference to Judge Coomer being evasive and not answering questions. And I believe the hearing panel characterized some of the things that he said or his responses as not being truthful. And this is from the Supreme Court opinion in that case. There's a footnote that says that we had already determined that he violated multiple provisions of the code, and so his actions before the JQC, we consider those actions as aggravating factors only in determining sanction. And so I submit to you, if you find that Judge Williams was not truthful and that she did not exhibit candor throughout this process, that fact can be used as an aggravating factor. And it is the same thing that I argued in Peterson on top of her violations. And I will end where I started. Now more than ever, we want the public, and again, the public as a whole, not just the people who support the judge who's found themselves in the middle of an ethics hearing, but the public as a whole. We want them to respect the judgments of our court, and judgment is the only power that judges have. And so when they've demonstrated that there is reason not to respect it, that's a problem. In this circumstance, the way that Judge Williams has demonstrated that her judgment should not be trusted warrants removal. And so that is my request. Thank you.
All right, thank you, Ms. Field. Did either panel member have any questions they wanted to ask either side before we
Well,
conclude?
we just blew right through what are we to do if we give her less than removal? We have this sanction of impeachment. I didn't write the law, but it says shall. So what are we to do with that, if anything?
So my position on the impeachment issue is that I don't think the panel at this juncture, even after you issue your report and recommendation, should do or report anything. And I don't view you as having an obligation to do so, because the Supreme Court has to make the final findings and determination in this case.
Right.
So after the Supreme Court opinion is issued, I believe the panel could either transmit it on its own or could direct the director to have it transmitted appropriately. I don't think there is a legal obligation for the panel to do that, especially given the fact that the Supreme Court opinion ultimately will be a public opinion.
And nobody addressed her
If I may
suspension.
just respond to that just briefly. There's a case, we were unable to find a whole lot of cases, but Richter versus Harris, 62 Georgia Ave 64, it's a 1940 case.
Yeah.
It talks about the legal obligation of whether or not, if there is a legal obligation for the panel or anybody else to have send it to the House. In that case, the plaintiff filed a lawsuit against the Speaker of the House and the Clerk of the House of Representatives, because that plaintiff had submitted petitions for impeachment and they were never submitted to the House. And so they filed, that plaintiff filed a complaint for damages against the Speaker of the House and the Clerk, and ultimately the court ruled in that case that there was no legal obligation to submit the petition to the House for consideration of impeachment. And I will say failures to rule or delayed rulings have generally been handled by the Supreme Court.
Okay, thank you.
The other on Gundy, wasn't Gundy, or didn't she admit to illegally jailing half a dozen defendants? And they had to, a lawsuit, mandamus had to be filed against Gundy. And the day it was filed, all of a sudden the inmates got out of jail.
So she did not admit to illegally jailing them. They were.
That's my word.
Okay, they were legally jailed, but because of her tardiness on whatever day those defendants were on the calendar, she was rushing through the calendar, did not hear their cases, and as a result, they remained incarcerated. And this was over the objection of the state and the defense, and you are correct. The public defender's office filed I think it was a petition for habeas corpus or some kind of petition to which she responded by granting everybody a signature bond. So that violation was part of the 90-day suspension and reprimanding Gundy.
Yeah, I am very troubled with, not only do we have to be fair, we have to appear fair. We're the appearance police. And so these other cases where I have personal knowledge of the sanctions being less than removal, but could argue that it's conduct that is either on the same level or some even worse. I don't know how to handle it. I'm struggling with that. So I don't know.
Did you want to address any of those questions, Mr. Banks?
I will say that as it concerns the fine, I do think that there is grounds for this hearing panel to find that if you do suspend, I think there's been some cases where judges have been suspended without pay. I know she doesn't want me to say that, but having said that, I do think that there have been some cases where judges have been suspended without pay.
They've been doing it since 1972. That's not my question.
Right.
I don't know of the authority to do it. That's all I'm saying.
Sure. Well, I do think they've been doing it, and to the extent that there's precedent that it has been done, I mean, if that's the authority, then so be it. As it concerns whether some cases are more egregious or not, and the culmination of cases, look, I mean, I do think that each violation would arguably be a public reprimand, but in total, if it moves, because there is a culmination of cases, if it moves it to the level of suspension, I understand that, but I do not think that a removal is warranted, because the cases that have been reviewed by both parties frankly, reflect a discipline that is less than removal, and that shouldn't be different for Judge Williams.
Any other questions? No? All right, thank you all very much. That will conclude our hearing, and so we can go off the live stream. Thank you, Mike.
I'm sorry, I do have one other